assume that most of the documents are going to get stamped.
Yeah,
If
provided we lay down the law that it must be stamped.
Please, my lord.
Avoid the confusion.
As it happened in Suraj Lamps, my lord. Today, nobody can actually get into a conveyance of property, my lord, without stamp duty being paid. So, my lord, that takes care. And my learned friend appearing for the appellant also pointed out yesterday the law from 3 countries, which are arbitration hubs. My lord, there it is very obvious because the strict regime of stamp duty payment is followed, which is also contemplated in our act. This problem does not occur. This problem occurs, my lord, because this leeway is given. So, my lord, that will take care. The observation of this honorable court today, a strict observation, will take care as far as the future is concerned. And, my lord, as far as whatever is pending, that will have to be complied with. So, my lord, that will take care of both aspects, the Stamp Act as well as the Arbitration Act. Now, my lord, I will also come to Justice Rao's order, which my lord had asked us about. My learned friend has brought it here on the Stamp Act, my lord, and in 3 months, how it has to be complied with, my lord. I will just, in the course of my arguments, also place that before the honorable court. But, my lord, just going now, once again, why, my lord, it is important to decide this issue in this reference. My lord, I had pointed out para 26.
You see, because you told that you'd be referring to the 6 judgments.
Please, ma'am.
The Bombay High Court, a full bench of the Bombay High Court in that Gautam Landscapes decided 2 issues. One is in regard to Section 9, the other is with respect to Section 11. In regard to Section 11, in Garware, it stands set aside.
Para 31.
It has been overruled, it has been found to be incorrect. In regard to Section 9, however, even Garware does not overrule it.
Because the issue was not before the honorable court, my lord.
What you're saying is, Section 9 has been understood to be requiring a separate treatment by Justice Nariman in Garware. He has only confined himself to Section 11 because apparently, like you said, Section 11 was the issue which arose there. Now, there are some issues which you would like you to address because now that you are here. There are several expressions which are being thrown about. I mean, void, 2G of the Contract Act is unenforceable. Now, Section 10 of the Contract Act says agreements are contracts if they are made with persons having, on their consent, lawful object, lawful consideration, and not rendered void hereinafter. Now, they have been understood in Mola as sections 23 to 30, which are void contracts. That's one thing. Then you have voidable.
Voidable.
Then you have invalid. Then finally, with respect to our section 11.6, say the word exist. Section 17 of the Stamp Act prescribes the time at which the stamping should take place for a document executed by somebody in India. It declares that it should be executed before or at that time. I mean, the stamp should be fixed before or at the time of execution.
Absolutely.
The 2 judgments, Justice Chagla and Madras High Court, which says that it should be somewhere near the execution. And Madras High Court takes a little more liberal view, but at the same time, it should be near at the time of execution. Section 62 of the Indian Stamp Act visits a person with a penalty, which is adjustable with under Section 35 of the Act, whatever is paid. So, an agreement, but now you go back to Section 2H
Absolutely.
of the Contract Act.
Yes.
Now, 2G of the Contract Act, which has been understood by this Nariman,
Yes.
to be that it is unenforceable and therefore it is void. Now, void because it is unenforceable, an agreement which is unenforceable, because there is a oxymoron, because if you say a contract is void, Because there is an agreement, promise supported with the consideration, and some of the agreements would have to be compliant. For example, say you take 299 of the Constitution. It would be invalid, in fact, if it is not done in a manner which is it's provided for after
As contemplated in law.
that is it. Therefore, what you're trying to tell you is the word unenforceable has got different shades of meaning. An agreement becomes unenforceable. For example, parties may enter into an agreement. It may be oral. We'll begin with the case of an oral agreement. An oral agreement where the law commands, for example, under Section 7 of the Arbitration Act itself, that it shall be in writing. There are several laws which say an agreement can only be in writing. You parties may agree, but then it's of no use.
Absolutely.
Within the meaning of Section 10, therefore, it will not apply. It doesn't exist as such. Now, an agreement in the case of Stamp Act has been the subject matter of discussion in Pollock and Muller under the Contract Act, if you just see it. What they say is, the substance of it perhaps appears to be a little confusion even in England, I say, because it's a contradiction in terms to describe it as a void agreement, a contract. An agreement is void because Section 2 describes it so. And an agreement becomes a contract unless it becomes void under Sections 23 to 30. This is the scheme
Of the contract.
Act. Now, what you're saying is, supposing, take the facts of this case, of the present case. You have a contract, parties were expected to stamp it in terms of Section 17 at the time of execution. They don't do it. However, they actually kind of act on it. Now, when they act on it, would it become enforced? Can you describe it as an enforceable contract? Or the words enforceable contract cannot be enforced? Is it with reference to the taboo against that agreement, not contract, that agreement being enforced through the state machinery, namely the courts, the tribunals, the public offices? So it is capable of two different shades of meaning. It is unenforceable in the sense that you cannot take it to a court, get it admitted into evidence, nor can you persuade the court to act upon it. Therefore, it becomes unenforceable. Parties may, for example, you may be laboring under the impression that it doesn't require stamp. But it's not your understanding that will, decide the fate of your case.
Under the regime that
it is a law which ultimately will take over. And if the matter cannot be enforced, somebody else points out it cannot be enforced in a court. If you bring it, it's not stamped. Court cannot act upon it. Because Section 62 also must be. It is a matter where the court, you have to pay on the pain of being visited with a penalty. So can the court under Section 11 and 8 say, no, we'll ignore all this. Just a matter of, it's a curable, which it is. So it really is a case of a very strange kind of a thing. We'll have to explain it to us. An agreement which is void, but not in the sense that it can never be brought back to life.
it can be. My lord is right.
This is
That's a minus.
yeah.
My lord, in fact, very
No, minus. Unenforceable, can you say it is existing? Because our journey is to find out the connotation of the word existing.
Because, my lord, in the course of my arguments, I also want to place before this honorable court that how this agreement is inchoate. So, my lord, because it has not reached its final conclusion in terms of the stamp duty not being paid. So, therefore, my lord, from Garware, therefore, the interpretation of the Contract Act, and that is what I would also, in answer to my lord's question, also place that. Because then if it is an inchoate, incomplete document because of the Stamp Act, what can or cannot the Honorable Court do. It is all right if the parties have acted upon it. But under the Stamp Act, can those parties actually come before the Honorable Court and ask for an active order?
So that's why we'd like you to just, read that 2H, 2G
I have
of the
it.
Contract Act. Because finally we'll fall back on the amicus.
There's some very interesting commentary on 2G in a Law Commission report, which I'll show, my lord, on stamping and 2G.
That's right. It is 2G.
An agreement not enforceable by law is said to be void.
Said to be void. Then an agreement enforceable by law is a contract.
It's a contract.
So it goes to a stage, and then you get a voidable contract in 2I. Now, a voidable contract can never be an invalid contract.
That is true, my lord.
A void contract, it can perhaps be described as an invalid contract and non-existent. This is the meaning of section 6A.
And my lord,
Now, when an unenforceable contract, if the reason for its unenforceability is removed, if, for example, you execute a document, it's to be registered. You don't register it. There's a period of 4 months within which you have to register a document under the Registration Act. You register it after, say, 2 months. Within time, after that. So in between, I mean, at the time, it remains a period of eclipse. Till the point of time when you get it registered, what is the nature of that document? It remains unenforceable.
that is my submission. That is my submission.
Therefore, enforceability or unenforceability must be viewed from the prism of it being enforced or not enforced through the legal system. Not that the parties act upon.
Not that the parties. Absolutely.
This is what we thought that one way of
Just
seeing
move the phrase is unenforceable by law. What that means, your lordships will have to address. It's not simply unenforceable by law.
by law. Exactly.
That has been interpreted in a particular way, which I will show.
Because if you don't get the sanction of the state, ultimately judiciary is the wing of the state, and people enforce their rights through either the courts, tribunals, public, for wherever you can enforce it. If you cannot enforce it, an unstamped document cannot be enforced unless and until it's stamped. So it remains unenforceable. It is in that sense, this is Najiman. In Garwari must be treated as having understood the 2H. When it progresses to the state where it is to be void, that is where the problem arises. So it is a kind of an interpretation, because void for the purpose of 2G is different from void for the purpose of 23 to 30 under Redwood section 10.
It's the same. I will just show that.
And the commentary is in fact good to suggest, say for example, take 65 of the Contract Act. A contract becomes void or is discovered to be void.
No, that's a subsequent.
What the commentaries would suggest is that those are cases where they are not really making a new contract for you, as you know,
Correct.
under 65.
Correct.
It's a doctrine of restitution.
Yes.
Somebody gets a benefit under a
Correct.
void contract.
Right.
You can ask the court, give it back.
Correct.
Sure. Apart from that, you can't go to a court for enforcing an unenforceable contract. So that's where we bring in the unstamped document. It remains unenforceable till it is stamped.
My lords, will have to see that paragraph 22 of Justice Nariman very, very carefully. And
That's right. We have to
that
obviously.
paragraph will have to be seen very carefully.
What we could find was, if you see the reference order,
Yes.
finally you see the reference order like you correctly pointed out.
Yes.
It is also riddled with mistakes.
My lord, there are three phrases which are used. My lord.
Sorry? Yep. To save time, if you just come to.
My lord, I have just reframed the questions. Would your lordship have a look at that?
So if you don't mind, paragraph 22. So,
Yes.
we can.
In fact, my lord, I'm going to point
At page 325 of the compilation, and because paragraph 21 describes, the issues which arose.
My lord, I have an issue with the third sentence.
That is
Third sentence.
in para 22 or
22. Third sentence.
in our view, the non-payment of deficiency stamp does
No,
not
no.
invalidate.
22 is when an arbitration clause is contained. Is that what you're reading? Lordship, sir?
My lord is reading 22 of Garware.
Of Garware?
No, we are reading NN Global. The order referring it
NN.
at page 325. You read,
All of us have the SCC copy, my lord. So we are little.
it's the same. Para 21, you can read para 21 of the SEC.
That is SCC only.
SCC. I'm
SEC
sorry.
only.
I'm sorry. My lord, 21.
In our view, the non-payment of deficiency of stamp duty on the work order does not invalidate the main contract. Section 34 provides that an unstamped instrument would not be admissible in evidence or be acted upon till the requisite stamp duty is paid. This would amount only to a deficiency which can be cured on the payment of the requisite stamp duty.
We thought that, that sort of does not do full justice to the scheme of the Stamp Act or Section 2J of the G of the Contract Act, and leads perhaps to an incorrect understanding of the content of Section 6A, subsection 6A. So you read on thereafter. At 24, you come to, please read 24.
The arbitration agreement contained in the work order is independent and distinct from the underlying commercial contract. The arbitration agreement is an agreement which provides the mode of dispute resolution. Section 3 of the Maharashtra Stamp Act does not subject an arbitration agreement to payment of stamp duty, unlike various other agreements enlisted in the
So,
Shinetsu.
pause for a moment. This itself has been pointed out to be wrong. It's been pointed out to be wrong because it is actually, it has to be stamped.
It has to be stamped.
Number one. Now, the other earlier part that the arbitration agreement contained is independent and distinct from the underlying commercial contract is based on an understanding of competence Action 16.
Please, ma'am.
So the fiction carried, there is based on a large body of, judicial work from both in England and in India, which is premised on the principal contract in which an arbitration clause may figure being treated as, the arbitration contract being treated as distinct and surviving so that it serves a functional purpose, which is to permit the parties to actually then adjudicate as to whether, for example, the main contract is terminated, destroyed. By a reason.
My lord, to give powers to the arbitrator.
Arbitrator.
That the parties can be before the
Absolutely.
arbitrator.
That is the purpose which Mr. Goyal argues. So that would not make it an independent contract for the purpose of stamp duty.
Absolutely, my lord. And my lord, that is the argument I will take for the purposes of Section 9 also.
And again, the same thing is said on the basis of the doctrine of severability, the arbitration agreement being a separate and distinct agreement from the commercial would survive independent of the, it would survive. That is where, you have to grapple with these subtle concepts. That what is voidable, enforceable.
Because, my lord, we are talking about the agreement stage and then we are talking about the contract stage. So, my lord, this is at the agreement stage. We have to see that stamping actually makes the document complete and not void.
And again, para 28 and para 28, that is where
Para 28, my lord.
para 28 at page 327.
Yes, ma'am.
This is where SMST is disapproved.
And my lord, 29, where there is an
Just see the para
erroneous.
28, if
Yes.
you don't mind.
My lord, I'll read it out.
Yeah.
In our view, the decision in SMST estates does not lay down the correct position in law on two issues, i.e. that an arbitration agreement in an unstamped commercial contract cannot be acted upon or is rendered unenforceable in law, and two, that an arbitration agreement would be
So we
invalid.
also that the first proposition does not appear to be the correct proposition, that it is what was laid down in SMST, that it is unenforceable in law, appears to be correct. Because how does it become enforceable if it cannot be acted upon by any court?
My lord, I would say that.
It
because
cannot be
section
received in evidence. See, section 35
has very
35 speaks about receiving in evidence. Section 49 of the Registration Act speaks about received as evidence of, in and of. That itself is a subject matter.
Lord, in fact, one very interesting point in section 35 is that the document cannot be acted upon registered. It can't even be registered or authenticated by any such person or by any public officer unless such instrument is duly stamped.
Yeah, we'll go on in your room.
The acting upon by the parties is rendered meaningless here, as per the section, my lord.
Yeah.
My lord was on para 28, so just in continuation, I will show para 29. Since
But
we are
having said all this, for the purpose of section 9, supposing somebody is coming with an injunction application, no, the other side says, okay, it's not stamped, or the court itself is, as this is Ravindran says, duty bound so more to examine whether it's.
if it comes, my lord,
it
the
comes,
word
it's
used is
produced.
comes also. Produced or comes.
What will be the result of saying that no, till it is stamped, we will not consider your application? Suppose you require an ad interim relief, and it is irreversible. To put it shortly, if the damage is irreversible, you are going to deal with the stamp duty, the time it takes. We know it. So that is why section 9. This is Nariman in Garwari. You come to page 117 of the same. Page 117. Absolutely. Page 117 of Garwari deals with the 2 points which has been found in Gautam landscapes. So
Para 30, my lord. But my lord.
30, para 30. Please, just the para 30.
Yes. So my
Please read
that,
that,
yes.
that's where you are.
Other High Court judgments were relied upon in the context of stamp duty being the judgments contained in JMD Limited versus Celebrity Fitness Private Limited, VD Sharma versus Swastik Infra Estate, Sandeep Soni versus Sanjay Roy, and ND Developers versus Bharati. In view of our holding in this judgment, these judgments have not declared the law correctly and are consequently overruled. A recent full bench judgment of the Bombay High Court in Gotham Landscapes versus Shailesh Shah, decided on 4th April 2019, has also been brought to our notice. In para 134 thereof, the full bench answered 2 questions framed by it as follows. In view of the above deliberation, we answer the questions as framed by us as follows. 1. Whether a court under the Arbitration and Conciliation Act can entertain and grant any interim or ad interim relief in an application under section 9 of the said act when a document containing arbitration clause is unstamped or insufficiently stamped in the affirmative. 2. Whether inter alia, in view of section 11(6)(a) of the Arbitration and Conciliation Act inserted by the Arbitration and Conciliation Amendment Act, it would be necessary for the court, before considering and passing final orders on an application under section 11(6) of the Act, to await the adjudication by the stamp authorities in a case where the document objected to is not adequately stamped. Now, my lord, both these questions, they were based on the same reasoning, the answers to these questions. Now, before the Honorable Court in Garware, there was only one issue of section 11. So, my lord, therefore, the Honorable Court says question 2, having been answered contrary to our judgment,
Correct,
is held to be incorrectly decided. Now, if my lord sees question 1, and I will take my lord to Gotham
the question
Landscapes.
is, Malvika, whether we should go into section 9 in a reference which is primarily based on interpretation of 11(6).
So, my lord, I will show the question also from para 58. if my lord sees the question itself, the question framed in para 58, my lord of NN Global, my lord will see that no sections are referred in para 58. Now, my lord, the basic premise in the question framed for the reference is, my lord, this severability and unstamping of an arbitration agreement. My lord, if that issue is decided, then it will automatically have an impact on Section 9. So therefore, my lord, the problem that will continue to arise is that whether the law, which is settled in terms of Section 11, what will be the impact of that law on 8 and 9? And my lord, in Vidya Drolia, 8 and 11, still the judicial review has been held to be in identical terms.
Up to 11 and 8, you are right, but not 9.
So, my lord, this is the problem that has arisen today. And my lord, I will try and place it and show that why, when a prima facie case has to be seen, and I will show Adhunik steels to my lord, that if a prima facie case has to be seen in Section 9, then the document has to be seen. Then the law as laid down by Garware, in case that is...
If you invoke Section 9, and it's an unstamped document, it's unstamped, within 3 months, arbitral proceeding has to initiate.
9th month.
If interim order is granted by the court in Section 9, within 3 months, the person has to file an application for appointment of an arbitrator to initiate the arbitral proceedings. At that stage, you will take an objection, unstamped or insufficiently stamped, whatever the objections are being raised, can be taken care of.
My lord, there are several...
But you want that the court should not initiate and grant any discretion on the first day when the application Section 9 is moved, only because your objection is not stamped.
My lord, I am saying that that is not...
That is curtailing the discretion which is required to be taken care of by the court at the given point of time. Otherwise, the damage caused to the party or this objection being raised, you can't put it back.
My lord, my
No restoration.
submission is that the
And
parties...
Insufficiently stamped is one thing. Unstamped is one thing. Unstamped is one thing which you can say, sorry, unstamped is required to be stamped, very good. But majority of cases which are coming up to the court are not insufficiently stamped. So every time when you raise an objection, suppose I, in my wisdom, by taking legal assistance on the document in question, I put all stamping which is possible. But still, to my wisdom, can fail on objection being raised by the parties. Now, every time, day in and day out, the other side will raise an objection insufficiently stamped. The question is whether that insufficiently stamped is a question to be inquired, deliberated, examined by the court, and record a finding.
My lord, today it is done.
At this stage, at the preliminary stage, according to you, meaning thereby everything is stalled because your objection is to beat out first in the first. Unstamped is one thing because everybody is on this common, this has to be stamped, undoubtedly. Unstamped document, fairly good. But it's insufficiently stamped, which is normally the feature comes forward in. How to deal with the situation?
My lord, we have
It's a good claim, and it is not insufficiently stamped according to me. Entry 7, you have invoked entry 5. So according to me, insufficiently stamped, put the matter back. Everything is stalled.
My lord, in a
And this fall can go on.
My lord, even at the initial stage, there can be, my lord, even at the stage...
So suppose there's one thing. Let us take 100 applications are filed in a month. And every party file an application insufficiently stamped. Now, all cases of 100 matters, either you take a call yourself in the presiding officer or send it to the High Court is there, you can ask your agent, authorized person under Section 2 of Section 33 and get it done. Now, everything you come into motion and the courts may record a finding of enforceability of the document for the purpose of passing further orders. Everybody has to wait for the orders to be passed. And who will decide insufficiently stamped?
My lord, I have actually gone through...
Somewhere you have to draw a line. Problem is coming only insufficiently, not unstamped. Because parties are all literate people. They are not going to put 2 papers document without being stamped. Stamping is there. Go back.
These are high value contracts, many of them, my lord is right.
So we have to put a trigger somewhere.
My lord, if I may just submit on this, I in fact have in a matter experiences. And my lord, in all these matters, what happens is, what my lord is saying, that whether it should happen with the court, but it will still happen with the arbitrator. And my lord, the matter that I am discussing here, my lord, there, the arbitrator had to take a call on the sufficiency of stamp duty paid, which is happening, my lord, in many matters that is going on, where the arbitrator then has to take a call. So the issue is whether you need, my lord, the decision to come at this stage, at the stage when the matter is before the honorable court in a 9, or whether this decision has to then be taken by the arbitrator. In both cases, my lord, the arbitration is not going on till this issue is decided.
Over 9 and 11 are quite different.
My lord, I bow down to that, but I am saying that today, what is held as per 11 will get applied to 9. So therefore, my lord, because the prima, and I will show from Adhunik Steels and SR, that a prima facie case, if it has to be seen, then the document has to be seen. The substantive contract has to be seen. And under section 35, the stringent strict provisions, whether that can be done at all, my lord.
Section 9 doesn't need any aid. Section 9, you see this Arbitration Act. It doesn't need any aid.
My lord, I'm saying section 9 hasn't got any similar line in terms of confining to the existence like section 11.
That's correct.
So
Section 9 is independent, not need any aid of Section 11.
Not
Or
at,
section 8.
not at all. But my lord, I'm saying that when section 11, if my lord still holds, then maybe can sail through and can reach the second stage. Section 9 definitely cannot, because when you are looking at issues of termination of a contract, invocation of bank guarantee, receiver taking over the goods, in all these matters, my lord, the clauses of the substantive contract are being seen. And my lord had also asked a question on court fees yesterday. My lord, there section 149 of the CPC, my lord, makes it very clear. Because that is, my lord, already introduced as far as court fees is concerned. Section 149, power to make up deficiency of court fees, where the whole or any part of any fee prescribed for any document by the law for the time being enforced.
Yeah.
For the time being enforced relating to court fees has not been paid, the court may in its discretion at any stage allow the person by whom such fee is payable to pay the whole or part, as the case may be, of such court fee, and upon such payment the document in respect of which such fee is payable shall have the same force and effect as if such fee had been paid in the first instance. So, my lord, this is to say that this is already inbuilt as far as court fees is concerned. And even after that, under Order 7, Rule 11, if it is not complied with, my lord, the plaint can be rejected. So, my lord, that is not there as far as the Stamp Act is concerned. Section 35 makes it so clear that nothing can be done till this is taken care of, and there is nothing to stop the parties from paying the stamp duty right at the inception or taking a seal of approval from the collector and moving ahead with the transaction. Both parties are at an equal footing at that stage. This will be an extension of the consideration involved in the contract, and this can be fulfilled. But to say that because they have not fulfilled this very strict legal requirement, but they cannot.
The problem is, the taking it to the extent of holding that an unenforceable contract is void with the meaning of 2G in respect of an unstamped document. That fact of void means void has different connotations.
Absolutely, my lord is right. My lord, I would, our reading actually leads us more to voidable. But I will come to that, my lord, when I am also on Garware.
Voidable is at the option of one of the parties.
Correct.
Because, my lord,
Void is a nullity. It goes
because of
non-existent.
because of not enforceable by law, my lord.
Yes.
So, my
If
lord,
you can enforce it on payment of duty,
on payment of duty,
then
therefore,
would
my
it be
lord,
a void document? That's our,
Absolutely.
this is our
My lord, I will
Juridical
endeavor
worry.
to take some assistance from what has been observed in Garbhare, and I will try and answer that question. My lord-
Garbhare only says, that because it is void, it is not enforceable. It is a void contract. That refers to 2G
2G, man.
and say this is so. But then doesn't pursue the matter to find out what if the unstamped document is stamped. Then will it spring back to existence?
My lord, Hindustan Steel is what I will show to my lord.
The
It
stand
says-
steel, of course, 42.2 has been considered.
Please, my lord.
Para 6.
Yes, my lord.
Para 6 deals with 42.2 and says that once it is fully stamped,
Please,
it is specifically expressed that it can be acted upon.
it can
So
be.
the argument that it cannot be acted upon, even if it is fully stamped, is rejected.
That was
That
absolutely
is gone. That
rejected.
is gone. No difficulty there. No difficulty there. We are concerned in the context of 2G, because we have to deal with that frontally. Where does it lead us finally? That the logical conclusion. Does it make it void in the sense of it irretrievable? Position is reached that it cannot give, meaning, life into it.
My lord, it will be difficult to say that it will be irretrievable.
Ah.
It will be difficult to say that.
So then will it be void?
So therefore, my lord, I am saying that I cannot say today that it will be void.
Yeah.
I cannot.
So then will it be unenforceable?
But I would have to say that it is unenforceable in law.
So it is a suspended animation.
Absolutely, as my lord observed. And I am only saying today, my lord, that if all this is actually considered for section 11, then in my respectful submission, we cannot leave section 9 out of it because of the substantive contract being involved. Here again, because the principles that have been used are again of severability, and the entire basis is that an arbitration agreement is not required to be stamped. Because of these two grounds, this section 9 finding, my lord, will have to actually be seen in the light of what is held for section 11. So, my lord, if I can just very briefly show the relevant paras from these four judgments, my lord, this will just clarify how the four judgments have considered these points.
What is to be stamped is the instrument.
Absolutely.
Prove that in that instrument, the arbitration agreement is also there.
And therefore, my lord, I am saying that Gotham Landscapes has gone completely wrong on that aspect. The moment, my lord, it actually considers severability to be a ground for saying this, that you can go ahead without the stamping of the arbitration agreement with the 9 as well as the 11. On that basic premise, if this error has been made, then, my lord, in the light of that, it has to be reconsidered. And if 11 is being reconsidered, if 8 is being reconsidered, I am saying for the very wide consequences, and because the result of all three is going to be the same as my lord said, section 9(2) also, all three will lead to the arbitration proceedings beginning.
So the Stamp Act has to have a uniform application.
That is our concern today, my lord, and therefore there is this confusion, as I said right in the beginning, that the law that will be applied for 11 and 8, 9 cannot be kept out of it, is all that I'm saying. If the law is applied in terms of NN Global, then, my lord, this whole issue is redundant. But if the law that is applied in terms of Garbhare, then, my lord, this issue of 9 will be very alive, is what I'm saying. And it will continue to pose problems in different matters where you have to go deep into the substantive contract. Then the court is acting upon it.
that we have distracted you enough. You can begin your submission in your own way.
My lord, these are perplexing questions in this matter.
That's right. These are also troubling us. So we thought upfront we should put it across to you. And then you can try and answer in the manner that you feel best.
My lord, para 146 of Vidya Rolia, page 235. My lord, I will just
Even that is doubted by.
absolutely, my lord. In this context of what I am saying, my lord, I just want to read out this para again because my lord will see why this problem will arise. If I may read out, my lord, in this context now.
You're reading Vidya Drolia.
Vidya Rolia, my lord,
Para.
page 235 from our compilation, para 146, which is the issue in reference.
Yes.
We now proceed to examine the question whether the word existence in section 11 merely refers to contract formation, whether there is an arbitration agreement, and excludes the question of enforcement validity. And therefore, the latter falls outside the jurisdiction of the court at the referral stage. On jurisprudentially and textualism, it is possible to differentiate between existence of an arbitration agreement and validity of an arbitration agreement. Such interpretation can draw support from the plain meaning of the word existence. However, it is equally possible jurisprudentially and on contextualism to hold that an agreement has no existence if it is not enforceable and not binding, as my lord was saying. Existence of an arbitration agreement presupposes a valid agreement which would be enforced by the court by relegating the parties to arbitration. And my lord, I was saying all three relegate the parties to arbitration, 8, 9, and 11. Legalistic and plain meaning interpretation would be contrary to the contextual background, including the definition clause, and would result in unpalatable consequences. A reasonable and just interpretation of existence requires understanding the context, the purpose, and the relevant legal norms applicable for a binding and enforceable arbitration agreement. Now, my lord, this is important again. An agreement evidenced in writing has no meaning unless the parties can be compelled to adhere and abide by the terms. A party cannot sue and claim rights based on an unenforceable document. My lord, this is what is going to come in the way of section 9s. Thus, there are good reasons to hold that an arbitration agreement exists only when it is valid and legal. A void and unenforceable understanding is no agreement to do anything. Existence of an arbitration agreement means an arbitration agreement that meets and satisfies the statutory requirements of both the Arbitration Act and the Contract Act, and when it is enforceable in law. So, my lord, this question that is under reference my lord, is on para 146. And I am saying that para 146 says a party cannot sue and claim rights based on an unenforceable document, which necessarily implies, my lord, approaching the Honorable Court under Section 9 and claiming rights under the substantive contract. It might be, my lord, the approach might be only because of the arbitration agreement.
Those observations are made in the context of Section 11. We should bear that in mind.
Absolutely, my lord. But the moment such a strong observation is
That's
made
true.
in terms
That's true.
of...
But the context in which the court makes it is Section 11 and also 8, because court says earlier 8 and 11 are
Identical. Says that, my lord. Says, Vidya Dolia says that.
9 is not really the back of the mind of the court.
9 is not considered, my lord, in Vidya Dolia.
When we are considering a judgment and it's being cited, you should not tear it out of context.
Not at all, my lord.
Factual,
But the problem is, my lord, that NN Global has put in para 37.
That's right.
Which I
we have
said,
seen that. We have seen that.
That is the
That
problem.
is where you're troubled by.
And
But that
what-
we can specifically leave it open, and the correctness of that, because maybe it might be decided there. We have enough, to go by,
But if Gotham Landscapes is deciding this issue based on the same reasoning 11 and 9, and my lord, then in Garware 1 is overruled on the principles, and the same principles are used for 9. But on the same principles 11, the reasoning is overruled. My lord, then in NN Global, if there is a reference specifically to Section 9 when it was not an issue before the court, Firm Ashok Traders, my lord, was not argued, and I will show why Firm Ashok Traders is not good law for this purpose, my lord, and why there's a caveat in Firm Ashok Traders itself. And
what you're suggesting is the larger strength, we can consider, vacating those observations which were really not needed in
Global.
NN Global, in para 37.
Please, my lord.
Because Section 9 was not the subject matter.
Not the subject matter at all. And because of
Was the subject matter in NN Global on the facts? 9 was also the subject matter of NN Global on the facts. Some bank guarantee had to be encashed. So perhaps, my lord, there was some 9 observations.
my lord,
Maybe.
it was in the
Maybe, my lord, I don't know, my lord. Maybe on the facts it arose there, but it certainly didn't arise in the first 2 cases. That's all I know.
May I just clarify? Sorry.
I don't know whether it was there or not.
May I just clarify?
You mentioned it that it was argued and then it was.
No. I'll just recapitulate. I had filed, NN Global had filed a suit.
We know that.
Right. In that Section 8 came. We had an interim order in our favor restraining encashment of bank guarantees. And was against that order, first a CRA and then a writ was filed. Writ was allowed and Section 8 was allowed. NN Global, in fact, dismisses the writ petition. So because my submit and then told us that please go to Section 9. Now, once the writ was dismissed, my suit and my suit was perhaps revived. And the interim I had perhaps also revived. But then I was directed to go to Section 9. The moment I was go to Section 9, I am compelled to initiate arbitration. This was never the issue. I had an interim order in my favor. But you let it try the civil court.
We can consider it. Because this is not an appeal from NN Global. We can say it was incorrect. It was incorrectly decided.
And the issue will be decided in the other proceeding.
and then the other proceeding. Leave it open for, that
Otherwise it'll be difficult.
you can't set aside as if it's an appellate court. You're not sitting as an appellate court.
So sorry. NN Global Judgment, Para 1.6 notes that there was a status quo order in my favor with regard to encashment of the bank guarantee.
That's right.
Your Lordships will say, your Lordships make no comment on the correct position regarding section 9 because it doesn't arise. Whatever your observations on 11, to the extent they are applicable, will be applicable, not applicable, not applicable. Either way, Mullah. Because certainly whatever observations your Lordships will be making is in the context of
Yeah, we can't be ending up approving it.
neither approving nor disapproving.
What is stated in para 37.
Or disapproving, my lord. Both ways. Either approving or disapproving.
And also leave it open, making it very clear that we
Making
are
it
leaving
clear,
it open.
not just.
That your Lordships have not pronounced on the
That's it.
section 9.
Otherwise, this entire thing is going to become much wider.
Correct.
And then we may
I
have
had
to
then some
rehear,
submissions on 9 also.
Validity and anybody else who might be.
No, that may be so. And
No, you're trying to project section 9, one would understand. It's arising. But then that's not part of the reference. Suppose if we go into that, then we have to start afresh practically this particular proceeding. We can't be starting from your, making submission.
my lord, my lord, would respectfully submit that 9 should have been addressed. My lord,
Should have been addressed, but it's not part of the reference.
My lord, I am saying here also 9 should have been addressed because of the impact, my lord, that
One would understand the impact issue. Suppose if we leave it open and say that we are not saying either way, that is also another way of, dealing with the matter.
So, my lord, except that, my lord, we are fine with that. But what will happen, and I will give an example with Black Pearl Hotels. My lord, there are matters, and we have all gone through these matters where, for example, there is a problem between a lease and a license. That whether this document is a lease or a license. This is exactly what happened in Black Pearl Hotels. Now, my lord, in these kind of matters, how can interim relief be granted? Because, my lord, the stamp duty assessment is different. The rights of the parties are different. This is exactly what was the law in Black Pearl Hotels, which followed, my lord, SMST estates. Whether it was a lease or a license, and based on that, what rights the parties will have. And my lord, on that ground, applying SMST estate, then the honorable court said, this honorable court said that the document necessarily has to be first adjudicated upon, that whether it is a lease or a license by the collector of stamps and then stamp duty paid. And only then, my lord, that document can be seen.
And this is what you say.
But then with all this, eventually we also have to look into the timeline that is part of this particular regime of arbitration.
And
No, I'm not saying that we have to ignore the law for that, but that is something which must also play in our mind as and when we are expected to deal with a matter like this.
Absolutely. But my lord, my submission was also that even the arbitration after the reference stage, even at the stage of section 17, my lord, how will the arbitration also proceed? So we are possibly from the court before the arbitrator, but the situation in terms of progress will not change very much. If today my lord says that this document cannot be read without stamping, cannot be acted upon, then the position will not change very much.
No, position will change in this fashion. The starter's gun would be fired, but they will not be running.
Yes, my lord. My lord is absolutely right. So we will have, my lord, many arbitrations starting, but stalled.
Is SLB arising from the Bombay judgment? Are you pending with the 2 judges bench?
It is not pending anymore, my lord. We also checked up on that. That matter was, my lord, settled and the SLP was disposed of. So there is no SLP pending against the Gotham Landscapes judgment.
But the other issue you can see, the effect of the 3 judges bench.
The thing is, the 3 judges bench, Mr. Banerjee, will also examine. And then global in 3 judges combination.
3 judge combination.
They have said something about section 9 also.
Para 37.
They have said
37.
Para 37.
If it is not in context of section 11, and it's not a question to be examined by this constitutional bench,
Correct. No?
And the subject issue is not pending.
No, my lord, because that's
And they say the party has
withdrawn.
settled and the thing has gone. Now, if we leave it open, then the three judges bench observation section 9, we may not examining in the constitutional bench. Either in some other matter, somebody will raise an objection, it will go again, one of the constitutional bench again.
May
And
or
then
not,
section 9 will be
may
independently
not-
examined by some constitutional bench.
May,
Constitution bench.
may, my lord, may agree. I will, my lord, I am open either way, my lord. We can, but it will lead to, my lord, expansion of this. And today there is, my lord, this issue is not really here. 9 arguments are very different. 9 arguments are very different, my lord. 9 is a case of interim relief. It's a case of interim relief. My lord, interim relief equivalent is 39 1 and 2. Now, my lord, in the case of interim relief, what happens is, my lord, I can answer this in 2 minutes, so cut short all this, my lord, if one has to go into it. My lord, in interim relief, the actual instrument, which is the original document, is not before you. You go on, my lord, typed copies. So, my lord, at that stage, the question of impounding does not arise. The question of impounding only arises when the original document is before you.
But are you acting on it?
No, my lord. It has to be an instrument. So
Okay, but you are
there is
acting
no
on-
instrument. No, my lord. I'll show that constitution bench. My lord, instrument means only the original.
That's right.
Right. So, my lord, therefore, my lord, 33 and 35 do not come in at that stage at all. Because 33, and there is a constitution bench on that, my lord. Fortunately for us, my lord, this had come, I'll come to that, my lord. So, in a 39 1 and 2, what happens is, what the court does, there's a Calcutta High Court judgment, it's in the compilation. What the court does is, because the court is a court of equity, it does not want the revenue to suffer. It says, I will give you the interim relief, subject to your giving security to protect the interest of the revenue. So, my lord, it is a subject to sort of order. It doesn't go 5 steps. I have also got a problem with 37. It doesn't go 5 steps further and say, I impound, I send, etc. It protects the revenue and gives you interim relief, leaving, my lord, the parties, when they produce the actual document, either before the arbitrator or in the suit or in the relevant, my lord, at the stage of trial, then all impounding, etc. But the mindset of the, otherwise, my lord, if on day 1 you are saying I impound now, my lord, then the entire interim relief concept goes for a toss. None of the judgment, my lord, there is a full bench of Gotham Landscapes, there is a judgment of Andhra Pradesh High Court, there is a judgment, my lord, now of Calcutta High Court. Nobody goes to the extreme position of saying in an interim relief case, day 1, I'm not even going to look at anything. Please, I impound immediately. No judgment has done that.
It is security collected for the value of the stamp duty,
So that,
but not stamp duty itself, because
Yes.
impounding, etc. is not
that's
happening.
how it has been worked out. There's a GTZ judgment, my lord. Your lordship will see it's in the compilation. I had anticipated this, my lord, I'd put it. But 9, my lord, therefore 9 has its own, my lord, dynamics. We can go into it, my lord. There's no difficulty. But I thought, my lord, because only 4 paragraphs are questioned, let us restrict it to that. Otherwise, my lord, we can solve every arbitration problem, my lord. This is a rare occasion where we have a constitution bench. Number of issues, my lord. I also was, my lord, led into existence, validity, prima facie, my lord, all these questions. So, my lord, I would respectfully submit this issue of 9 be left, my lord, untouched. Whatever your lordships will say in, supposing your lordships say in 11, the view is accepted that you have to impound day 1 and go ahead. That parallel can be used. Your lordships is a constitution bench. It can be argued you've impliedly overruled whatever has been said in NN Global. It will be argued. If that impact is there, it will be there. It will be there.
What more, Madhvika? 1 hour. Of course, we have been interrupting you, but we'll keep quiet now.
My lord, now I will just point out on this, my lord, Adhunik Steels, I am on this issue, my lord, to say if Adhunik Steels, my lord, was not a part of the compilation, but because of the submissions yesterday, my lord. This is 2007, 7 SCC 125. My lord, this is to say that whether impounding happens or not at the 11th stage, when we are on acting upon and we are on seeing the prima facie case.
Prior to 6A. Prior to 6A.
Please, my lord. But my lord, this is only on the issue, my lord, of interim relief that I am showing to my lord. The approach that at the initial stage only the existence of an arbitration clause need be considered is not justified. In Siskina Cargo Owners versus Distos Compania Naviara, Lord Diplock explained the position. A right to obtain an interlocutory injunction is not a cause of action. It cannot stand on its own. It is dependent on there being a pre-existing cause of action against the defendant arising out of an invasion, actual or threatened, by him of a legal or equitable right of the plaintiff, for the enforcement of which the defendant is amenable to the jurisdiction of the court. The right to obtain an interlocutory injunction is merely ancillary and incidental to the pre-existing cause of action. It is granted to preserve the status quo pending the ascertainment by the court of the rights of the parties and the grant to the plaintiff of the relief to which this cause of action entitles him, which may or may not include a final injunction. So, my lord, it is not about impounding at the stage of 9. It is about saying that this relief cannot be granted till this document is stamped or adequately stamped.
Yeah.
My lord, in fact, there is another Delhi High Court judgment by Honorable Justice Muralidhar, which I will just give shortly, my lord, after making the submissions, which is Avantha holding, where Section 9 relief was not granted, my lord, on an unstamped document. But, my lord, before that, just if I may take my lord to Gotham Landscapes, because, my lord, I was also showing para 61 of Gotham Landscapes, which is at page 64, where, my lord, I was saying that the nature and character of the document has to be seen, and therefore, which was in the context of a lease and license, and therefore this problem will occur of section 35. And my lord, if para 65, 66 and 67 is seen on page 66, this becomes the basis, my lord. This firm Ashok Traders, I will very briefly just read out these paras. In the case of firm Ashok Traders, the Supreme Court has held that the right conferred by Section 9 cannot be said to be one arising out of a contract. The qualification which the person invoking jurisdiction of the court under Section 9 must possess is of being a party to an arbitration agreement. This is nothing to do with the relief which is sought for from the court or the right which is sought to be canvassed in support of the relief. The arbitration clause constitutes an agreement by itself. It is therefore held that the arbitration clause being a separate agreement from the main contract, and accordingly it is only the arbitration agreement which would have relevancy for the purpose of an application under Section 9 of the Arbitration Act. In our view, the judgment...
Yeah, go ahead. Yes.
In our view, the judgment of the Supreme Court in the case of firm Ashok Traders would squarely apply to the facts and situation at hand. My lord, this is where the court is discussing whether the court can entertain and grant interim or ad interim relief in an application under Section 9. And this is based, my lord, the reasoning on firm Ashok Traders. And para 67, the respondents pressed into service the bar under Section 34 of the Maharashtra Stamp Act while entertaining an application under Section 9 of the Arbitration Act. We are inclined to accept the submission of Dr. Sathe, the learned senior counsel, that for the purpose of granting interim measures, whether by way of interim or ad interim under Section 9, the said relief is not arising out of a contract containing an arbitration agreement. We are therefore of the view that even if the main agreement containing arbitration agreement is not stamped or insufficiently stamped, there could not be any bar against the court hearing the application under Section 9 of KCA for interim measures to grant ad interim or interim relief. This is, my lord, the reasoning. My lord, this severability becomes the reasoning of saying this and firm Ashok Traders. And now, if my lord will see, my lord, para 45C of the same judgment discusses, my lord, firm Ashok Traders. This is page 53. My lord, after discussing Interim Finance and SPP versus Patel Engineering.
Yeah.
My lord, in 45C, firm Ashok Traders is discussed.
Yeah.
My lord, which was actually on the locus of a partner, my lord.
Yeah.
My lord, if on page 54, my lord sees in the middle of the page, the underlined portion, the right conferred by section 9 cannot be said to be one arising out of a contract. My lord, this is the line which has been used to lay down this entire law as far as section 9 is concerned in complete contravention of section 35 of the Stamp Act. Now, if my lord sees firm Ashok Traders, because my lord, we are saying that this is an absolutely stray observation, my lord, without any reasoning. 564, it's a prima facie opinion on completely different and peculiar facts of that case. And my lord, the last para 23 at page 580. It was only, my lord, a prima facie observation confined to that particular case, to the disposal of that particular case. Whether a non-signatory to a partnership agreement, my lord, will have the locus to approach the Honorable Court under section 9. And my lord, in para 23, the Honorable Court states, before parting, we would like to clarify that whatever has been stated here and above in this order is not in any manner intended to be a reflection, much less a finding, on the merits of the case of either party, which shall be available to be determined on evidence and material brought on record in any duly constituted legal proceedings, whether before the arbitral tribunal or before the court or any other forum. All that has been said here and above is by way of prima facie observations confined to the disposal of the present appeals. And my lord, in the Honorable Bombay High Court, firm Ashok Traders was argued to place it as binding law, my lord, and on the basis of that, it was held that section 9 is not arising out of the main contract. So, my lord, in my respectful submission, that was a completely incorrect reasoning and which has led to this problem after receiving, my lord, some sort of a stamp of approval by this Honorable Court in NN Global. Now, my lord, I had already shown Adhunik Steels. If I may just point out SR versus ArcelorMittal, only one paragraph, para 48 from there, my lord, I will read out.
The IBC, is it?
My lord, this is SR is, my lord, section 9 again.
No, Adhunik, which para you were reading?
My lord, in SR, I'm reading para 48. Volume 2, page 67. This is volume 2, page 67.
Volume 2 of your compilation.
My lord, there's a second volume where, my lord, some extra judgments, my lord, Naina Thakkar and all we had put in. Naina Thakkar starts at index number 26, serial number 26 in the index. And then, my lord, SR is at serial number 31.
Yeah.
My lord, this case discusses the scope under section 9 and only one para I'll show to my lord. Section 9 of the para 48. Section 9 of the Arbitration Act confers wide power on the court to pass orders securing the amount in dispute in arbitration, whether before the commencement of the arbitral proceedings, during the arbitral proceedings, or at any time after making of the arbitral award, but before its enforcement in accordance with Section 36 of the Arbitration Act, all that the court is required to see is whether the applicant for interim measure has a good prima facie case. My lord, I am saying this prima facie case cannot be seen without looking at the substantive contract. Whether the balance of convenience is in favor of interim relief as prayed for being granted, and whether the applicant has approached the court with reasonable expedition.
This paragraph doesn't address the question you are raising, but we are on the point as to whether in this reference we can address the question you are raising.
My lord, the reason why I'm saying that this has to be addressed in this reference is that I am saying that once my lord decides, if my lord decides that
No,
section 35,
If you say 9, 11 and 8 are on the same footing, then whatever we decide in 11 will guide that. We need not go into that. If they are on different footing, then in this reference we cannot answer them.
so my lord,
Our reference, we are bound by the terms.
my lord,
Points on which
I also wanted to show from that paragraph 58, my lord, that the reference itself, the reference question itself, as my lord had observed, was incorrect because of the wrong premise in the reference question about the arbitration agreement not requiring stamping. And I'm saying that is the underlying reasoning that has been used for 8, 9, and 11.
that is the thing, we did not answer that.
That
is reference.
That, my lord, that will.
So if we answer 11 and according to you 9 and 8 will stand covered by what we say on 11, then you will have to take up the point in a different case where this question is raised.
So, my lord, that is what I am respectfully submitting, that if my lord decides to not actually go into this question in this reference, what my lord decides under 11, my lord, will have an impact, is the
But
point I am laboring to
we
make.
may refrain from making that comment also, because that is also not within the mandate of this reference.
So, therefore, my lord will also have to see whether this reference has the mandate in such a way that it automatically covers 9. That, my lord, I can only submit, and my lord will have to see whether the point that I'm laboring to make, whether, my lord, it actually is correct on the facts of what the reference actually includes. Because I am saying the moment the reference covers such wide terms and has an observation in terms of the substantive contract not being required to be stamped at that stage when the matter is being referred to arbitration, I'm saying the consequence of 8, 9, and 11 is the same, the starting point of the arbitration. So how can there be a different principle today? My lord is right that 11 principle will cover the 9
In
principle.
the event it covers, then you need not argue. In the event it doesn't cover, then again new parameters will have to be examined.
My lord, today, at least, my lord, to the extent that firm Ashok Traders I have shown to my lord, as far as Naina Thakkar is concerned, that was also shown to my lord to say that the observations.
Many cases, there are observations which may cover 9 and 8 also. But in this reference, whether we need to address that or not.
Please, my lord, the difficulty today is that if in the reference, finally, if the Honorable Court says that it cannot be held that the substantive contract can actually pass muster without being stamped at this stage, then, my lord, it will have an impact. And because it has come as an observation in para 37 in NN Global, and, my lord, the para 58, which is the main para framing the question.
Maybe another reference or a higher strength.
My lord, we will again get an opportunity to address, but my lord, if I may, in the light of what has actually been held in Gotham Landscapes, where, my lord, now nothing from Gotham Landscapes is pending before this Honorable Court. Now, my lord, only going over to the two judgments that I pointed out, Naina Thakkar and, my lord, Anasuya Devi. My lord, again, the observations in Gotham Landscapes was incorrect as far as Naina Thakkar and Anasuya Devi was concerned. Naina Thakkar, my lord, was a case where under section 8, the Honorable Court said that SMST estates applies, and also said, my lord, that because in these proceedings, the party claiming these rights had not shown any desire to pay the requisite stamp duty. Therefore, no relief can be granted. It is not as if the court can wait endlessly and grant relief after the party goes and pays the stamp duty. So, in light of that, my lord, the relief was denied. Now, Naina Thakkar very well applied the law of SMST estates. But again, my lord, it was incorrectly held in Gotham Landscapes that Naina Thakkar is a case where the Honorable Court says that SMST estate, this law will not apply to Section 8 proceedings. My lord, similarly, Anasuya Devi was a case where it was a Section 34, my lord, the stage of stamping at the stage of Section 34, where the Honorable Court said that you will raise this issue in a Section 36. In the light of that, my lord, that matter was decided. Now, in Gotham Landscapes, both Naina Thakkar and Anasuya Devi have been incorrectly considered. So, my lord, therefore, the entire premise of going ahead in deciding Section 9 is based on firm Ashok Traders, Naina Thakkar, Anasuya Devi, whereas Black Pearl Hotels, as I pointed out, which talks about the nature and character of a document, which is even mentioned, my lord, is not considered in its right perspective. Black Pearl Hotels also follows SMST estate. My lord, there is one order of the Honorable Delhi High Court. It's a short order, my lord, but it really captures the law on this issue. Therefore, my lord,
No, has that law, point of law been dealt with any of the Supreme Court judgments? Letter.
my lord, in
that event, it can be part of your argument.
My lord, we really tried to look for it, but we have not been able to find it. But Justice Muralidhar's judgment actually captures this very point. So, my lord, this is a Delhi High Court judgment, but we just wanted to place it so that, my lord, will see that Section 9 relief was not granted on an unstamped document. For this reason, applying the law of SMST estate. If my lord just sees in para 16, SMST estate is discussed, and then in para 17, it says it is plain, therefore, that as far as the present case is concerned, this court is required to proceed to impound the LSA in original under Section 33 ISA and follow the procedure under Section 35 and 38 ISA. And my lord, then para 19, if the petitioner makes payment of the stamp duty and penalty as determined by the collector of stamps within the time stipulated, it will be open to the petitioner to also file an appropriate application under Section 17 of the Act before the learned arbitrator, which will then be decided.
Forward SMS. It is forward SMST.
That's what I was saying. Please, my lord.
So I think.
My lord, then only, my lord, what I wanted to show thereafter, my lord, are the Garware paragraphs, which my lord has already seen, my lord.
We have seen that.
Please, my lord. My lord has seen para 28 and 29. 29, my lord, discusses existence. And my lord refers to Hyundai. And my lord, also that, also in para 19 and 22, which is very important, my lord, of Garware, because as my lord observed, the Stamp Act applies to the agreement as a whole. That is what is very important, my lord, for our purposes also, for the purposes of arguing Section 9. That if it is applying to the instrument as a whole, then you cannot then separate for the purposes of interim relief. And my lord, in para 37 of Garware.
You're intervening on the basis of some pending litigation where.
Section 9 pending litigation.
What is the stage of that case?
My lord,
what happened in that case?
My lord, there also from the Bombay High Court, there was a Section 9 order, which this Honorable Court has stayed because of the pending reference.
Okay.
So, my lord, that is the reason. That is why, my lord, we say that it has.
So the pending reference in this case?
In this case.
Or some other case?
Before my lords. In this case, my lord. Before my lords. My lord, then the paragraphs in Vidya Dolia, my lord, where in para 112,
One another aspect you will have to look into it in section 33. The question of impounding, see, it is not arising only when it is produced.
When it comes also.
It says that when it comes in the performance of his functions,
Please, my
that is also relevant. That's also relevant. In that situation, it is not necessary that that document is produced before the court. That is why these two, in both occasions, it shall, that is.
Absolutely, my lord. It shall. My lord is absolutely right. It shall. Produced comes. Very important words, my lord, because.
That shall involve.
Yes, my lord.
Two instances, when it is produced or when it comes to the.
Because, my lord, the court cannot be oblivious of the fact that what you should have done, what your compliance should have been, has not been done. But today you are here before the Honorable Court asking for some sort of relief. So that, my lord, might be a very innocuous thing as far as section 11 is concerned, which is merely to refer the parties to arbitration. But it is a substantive relief when it comes to section 9. It is absolutely deciding in some manner, maybe for the time being, the rights of the parties under
That is why we say, see, at that stage of 9, it is performing the function. At that stage, it comes to the knowledge of that, oh, this is not this is insufficiently stamped.
Absolutely.
If that is the opinion or that is the formation of the opinion, then necessarily the question is, going by the express shall import. How can that be postponed at that instance itself?
It has to be, my lord is absolutely right. This is what we are endeavoring to place before the court. My lord, just a few paras from which I will not read out, but I'll just point out to my lord because my lord has seen Vidya Dolia in some detail. 112, para 112 at page 216 of Vidya Dolia. My lord, I only wanted to point out 5 lines from the top because this discusses the underlying.
There I want to say one more thing. At that stage, when it comes to the notice, it is not the discretion, it is the duty.
Absolutely, my lord. That is why the words of the section, my lord, are so important.
And what is the duty? The duty is to import.
And whether it is produced or whether it comes, I am saying that it cannot be ignored. For any of these sections, it cannot be ignored. And even if for some reason, because of the wordings used in 11.6a, it is being postponed, it cannot be done in 9 because there are no similar words in 9. So the rigors of 33 and 35 have to be followed. And something that has not been done at the stage it should have been done cannot now require the court to be so flexible in its approach that it is all right, you will get all your reliefs, all your rights will be protected, and you can do this later. My lord, there are some High Court judgments also to say that if lines I wanted to show from 112. Because
Vidya Dolia.
My lord, Vidya Dolia, page 216. This is volume 1, my lord.
Yes.
My lord, in this, when Interpon was discussed for the purposes of severability, the Honorable Court said, thereafter in Garware, Waldrop's reference was made to para 83 in Interpon, wherein the concept of severability of arbitration clause or agreement from the underlying contract was dealt with. And it was observed that it is necessary to ensure that the intention of the parties does not evaporate into thin air when there is a challenge to the legality, validity, finality, or breach of the underlying contract. So, my lord, on this breach, I want to just lay emphasis that this breach of underlying contract is what is contemplated here in Vidya Dolia. And my lord, therefore, it becomes necessary to see that what is the duty at that stage? What is to be performed?
In fact, this question, that is SMST, come to page 9 of your compilation, paragraph 21 and 22. What has been laid down? What is the duty of the court has been laid down there? Now, that has been sort of overruled by the referring court. Read 21 and 22.
Therefore, when a lease deed or any other instrument is relied upon as contending the arbitration agreement, the court should consider at the outset
99.
whether an objection in that behalf is raised or not. Whether the
Just a
Please.
page 9. Yeah.
Whether an objection in that behalf is raised or not, whether the document is properly stamped, if it comes to the conclusion that it is not properly stamped, it should be impounded and dealt with in the manner specified in section 38 of the Stamp Act. The court cannot act upon such a document or the arbitration clause therein, but if the deficit, duty and penalty is paid in the manner set out in section 35 or section 40 of the Stamp Act, the document can be acted upon or admitted in evidence.
So that this is a law which has been laid down. Only question is whether 6A will make a difference in this.
Absolutely, my lord.
6A was intended to cater to some other issues with Parliament found courts are actually overstepping their limits.
Absolutely, my lord. Legislative
Minimal
over-
interference, section 5, the Act, and things like that.
My lord, then on Vidya Dolia, my lord, one more para, 154.4. If my lord just sees, this is on the deadwood issue that was, my lord, dealt with.
That we need not be going into deadwood issues. We don't have.
My lord, I only wanted to say that.
We'll be reviving the old debate.
My lord,
Going to deadwood, you know.
not otherwise, my lord, only in the context of Stamp Act, I was saying that going by the concept that has been laid down in 154.4, at that stage, my lord, when it is starting the proceedings, all these issues can be dealt with. And my lord, because the powers under the Stamp Act are quasi-judicial, and my lord, in our submissions, I will not trouble my lord with all those judgments, but in our submissions, my lord, we have put in those judgments which actually show that Registration Act, how the powers under the Stamp Act are quasi-judicial. It has been held in several judgments that the Registration Act powers are administrative in nature and the Stamp Act powers are quasi-judicial. And then, my lord, of course, reference, revision, then, my lord, even approaching the constitutional courts. So in that sense, my lord, the two regimes are completely different. And that is the other error, my lord, in NN Global, where it says the principles of Registration Act should have been applied. So, my lord, therefore, this and my lord, in Vidya Dolia, in my lord, the second supplementing opinion, my lord, there in para 229, the prima facie case concept has also been discussed. Though not, my lord, I must.
That will be
not,
taken.
Yes. My lord has seen that. That is why, my lord.
Anything more?
My lord, only in NN Global, I have shown the error to my lord.
Yes.
And my lord, now in the light of that, my lord, this para 29, as I said, that the Registration Act has been applied, and therefore the entire premise in NN Global is wrong. If Garware is actually considered to be good law, then, my lord, the paragraph either from NN Global has to go, which covers section 9, or, my lord, the reference has to be extended to see that what will be the impact of this honorable court's finding on section 9. And, my lord, the clarity that is needed today as far as interim relief is concerned, because today this honorable court that this document cannot be looked at all till the compliance is made, then, my lord, we respectfully submit that section 9 relief cannot be granted, whether the document is impounded or not, or whether, like in Naina Thakkar, the parties are told you go and you do the needful and then come back to court. In either case, the interim relief without looking at the substantive contract cannot proceed.
Yeah. Well,
And for the respondent number 1.
yeah, you are.
Not have filed a compilation.
Where is your?
I'm very sorry, my lord, there was one page that The appellant had drafted, my lord, a suggestion.
I put to myself as a counsel, as an applicant in a section 8, 9, 11 application. What information should I place before the Honorable Court to perhaps make a first look, estimate of whether what I have done stamp duty is right or wrong? So, Milods, I drafted, Milods, a paragraph 2 of any application, be 8, 9, 11, be what information I can place to the court immediately so that a prima facie view of what stamp duty is paid or not paid is set out. That's what I had done. Paragraph 2 would state arbitration between the parties is contained in the instrument titled so and so. Under this instrument, we have to give a brief description, contracts, right? It's a contract for transportation, sale, whatever it is. Then 2.1, whether it has been stamped or has not been stamped under the relevant Stamp Act. Then 2, stamp duty of rupees 100, which this would be different because 6 states have their own stamp acts and the Stamp Act has a different value. Of rupees so and so has been paid on the arbitration agreement. Name of the act, Schedule 1, Article 5. The residuary clause would be different because in my compilation, Volume 3, the 6 state acts that I have placed. In this, it is Article 5C. In Maharashtra, the residuary is 5H capital B. So this perhaps would be different. Then the third submission paragraph would be stamp duty of dash is paid on substantive agreement. Has been paid under what article that you paid? 1. And if it is exempted, the substantive article is, the substantive agreement is exempted. Under which clause? So a prima facie view on stamp duty, like what we do in SLB, a declaration is given. So this is sort of a declaration on stamp duty.
It's a suggestion from you.
But this is my suggestion. As a counsel, how can I assist the court in perhaps having a first look on stamp duty? That's all.
After 70 years of assistance, still we are not able to clear the doubts of the people.
Let's,
You are giving a suggestion now. Go back to the regime when there were suggestions coming forward from the lawyers club.
Lord,
And
man-
still we are rolling now in the same circle.
Mansfield to modern times.
That's only restriction is. Ordinarily, when you say order 39, you want to all. You file a suit. And along with the suit, you disclose all facts. And along with the suit, you file application. And then ask the court, call upon the court that please consider my interim relief. Here is a situation where substantive proceedings still not initiated. You have a time. The law itself permits you. But at the same time, you can go to a court for interim relief without the substantive proceeding being instituted by you. Now the question is, if you have a right to approach for interim relief without the substantive proceedings being instituted or put into motion, what are the requirements you have to comply with for the court to call upon for passing of interim? Now, if the court go on to this jugglery of unstamped, insufficiently stamped, all the, I think the very purpose of Section 9 frustrated.
my lords have right. 9 perhaps, no, we did not have it. But this is what I could think of best to assist a court.
And one thing that's going on, I'll tell you, unstamped is one thing very clear. But the regime of insufficiently stamped is a very grey area.
One party
Now-
can say 10 rupees, other can say 100 rupees.
So, with the person who entered into a contract, with his wisdom and with the legal assistance, whatever is available, because very high value contracts coming forward in arbitration, you are not getting day in and day out arbitrations here. Parties take recourse to all legal assistance to the extent possible. You are not coming with the contracts or agreement which are not stamped. They are stamped. The objection is insufficiently stamped. Now the question is, this trigger of insufficiently stamped is being taken care of at the first stage because you say, because it's not entry 5, entry 7.
May I just point out, we had seen section 33. Section 33 says even before you execute, you have the option of going to the collector and taking his opinion. Number 1. Number 2, you have stamped the document. Still you can obtain the opinion of the collector. Sir, I have paid 10 rupees. Whether it is 15 rupees or 20 rupees, please take. Once you pay that, he makes an endorsement. That endorsement becomes final. You still have option, provided there is a willingness. If there is no willingness, because all this is an academic exercise. And besides the Malaysian Airlines order by Justice Jagannatha Rao, Section 11 order was, the power of body was impounded in this court. And stamp duty was.
Even in Murli there is order also. He has said for impounding and go to the collector now.
Yes.
Wait, please, Your Lordship.
Yeah.
I have filed a compilation, a small compilation compared to
How
all
small
the
is it?
very small method. Yes, Your Lordships, towards my lord, the origin, evolution of Arbitration Act. I'll first submit, my lord, that our arbitration.
1 minute. You are appearing for intervener.
Respondent number 1.
You have brought in also my debates also.
Yes, my lord, because I felt, my lord, I am before your Lord, and it's an interpretation. It's a constitutional issue. I thought it is a must. Debates are before your lordship. Because that is the basis, my lord. So, my lord, the debates, I'll take your lordships to the debates first, my lord. Then I'll take your lordships to the model law. Then I'll take your lordships to Justice Bandari's judgment, my lord, in an arbitration application. Then a judgment as regards the harmonious construction, my lord. And then, my lord, on section 5 and interpretation of statutes, my lord. And I'll keep my promise, I'll close in half an hour. Now, my lord, I'll take your lordships to the debate, my lord. Page 1 to 19, just the interesting paragraphs, my lord, so that page 8, my lord. Page 8, my lord. My namesake, my lord, the then Law Minister Ramakant Khalap. I am Reddy and he is Khalap, my lord. The Law Minister, my lord, this was in 1996, my lord, 1st August 1996, my lord, during those 1996 arbitration and conciliation amendment, my lord. By then they were sick of, my lord, the problems that were being faced by the Arbitration Act, and they thought that there something has to be done.
Yeah.
Madam, the need for, this is the Law Minister, my lord, Honorable Law Minister the then. Madam, the need for reform in the law relating to arbitration in India.
Where are you reading?
My lord, page 8, man. Page 8.
After that extract.
Sorry, after that.
Madam.
Madam, the need for reform in law relating to arbitration in India has been widely recognized. The Supreme Court, in one of its judgments dealing with arbitration under the Arbitration Act 40, stated that the way in which proceedings under the Act were conducted and without exception, challenge in courts had made lawyers laugh and the legal philosophers weep. In a more recent judgment, the court has observed that the law of arbitration should be made simple, less technical, and more responsive to the actual realities of the situation. Then, my lord, the last para in that line. On examination, this is where, my lord, the UNCITRAL model steps in. On an examination of available models and suggestions received from various interests and experts, it was felt that there is a definite advantage in repealing the Arbitration Act 1940 and enacting a new law taking into account the UNCITRAL model law. The UNCITRAL model law has harmonized the common law and civil law concepts on arbitration. My lord, my endeavor before your lordship would always be that there is harmony among the, my lord, Arbitration Act, Stamp Act and Contract Act. There is total harmony, my lord. All the acts can be given effect to, and none of those acts renders the other act redundant. That is my respectful submission. Now, my lord, then there are the discussions, my lord, alternative forum and all that. Then I'll take your lordship to the UNCITRAL model, page 26, my lord, the relevant section, article, which relates to the section in, my lord, the Arbitration Act, page 26, my lord. 26, my lord. Page 26, this is article 5, my lord. Similar to section 5 of the Arbitration Act. My lord, in matters governed by this law, no court shall intervene except where so provided in this law. My respectful submission is, my lord, Arbitration Act is a code by itself, my lord. There is a mechanism under the Act. My lord, when I read section 2B of the Arbitration Act, my lord, 2B is very clear, my lord. It says, it defines arbitration, my lord. 2B. Arbitration agreements means an agreement referred to in section 7. We don't have to borrow, my lord, anything from the Contract Act or the Stamp Act at the stage of section 11. Because it is a valid, my lord, and enforceable agreement under the Arbitration and Conciliation Act, because 2B says arbitration agreement means an agreement referred to in section 7. even a fax message, my lord, or a document signed, unsigned, telegrams. My lord, these are all agreements.
Can you ignore the Stamp Act?
Stamp Act, my lord, is in harmony with Arbitration Act. My lord, Section 11 can be given full effect. The machinery under the Arbitration Act can be put in motion. Then, my lord, at the same time, within that machinery, my lord, Stamp Act can be taken care of.
Oh,
No, but how
will you
how
do
are
that?
you, how
Yes, my
are
lord.
you determining this sequence?
In this sequence, my lord,
No, why? this
application
sequence?
is made. Yes,
The Stamp Act says something else.
my lord, Stamp Act has Section 17, my lord, has to be read. Section 17, my lord, has to be read with Section 31.
31.
Yes, 17 cannot be read divorced from 31. 17 says, my lord, 17 says, instruments executed in India, all instruments chargeable with duty and executed by any person shall be stamped before or at the time of execution.
Correct.
Now, my lord, this has to be read with 31.
Good.
31 says, when any instrument, whether executed or not, or whether stamped or not. Now, my lord,
Please
this,
read completely.
yes, my lord, stamped or not is brought to the collector, and the person bringing it applies to have the opinion that the officer is as to the duty with which it is chargeable and pays a fees, such amount not exceeding so and so. The collector may, in such case, district collector shall determine the duty with which the judgment of the instrument is chargeable. Now, my respectful submission is, my lord, an application is made under Section 11. My lord, it can be referred, my lord, to the arbitrator. And my lord, Then, my lord-
is not the court acting on the instrument?
No, but it's
which
only
is not stamped.
No, my lord, it's
Contrary to Section 35, 34.
no, my lord, this is my lord, Arbitration Act is a special act.
Huh?
Arbitration Act
Ah.
is a special act.
No, Arbitration Act is not said. When you say a special act, we agree.
Yes, ma'am.
In the sense that with reference to what is it a special act?
My lord, stamp with the Contract Act.
Does it?
So does it override?
Every
It doesn't over. My respectful submission, my lord, they can coexist. Application is made under.
If they coexist, then both the acts have to be applied.
Yes, my lord. Section 11 application is made, my lord, or section application reference is made. And my lord, a time limit is fixed
Your
for
argument
payment.
is at the Section 11 stage, it should be divorced from the Stamp Act, and maybe at a later stage, Stamp Act would be introduced.
Yes, my lord, it will be
But
giving
that's
effect to
not-
both.
That's not the scheme of the Stamp Act.
My lord, your lordship may have a look at this Justice Bhandari's order in arbitration application. Then I'll go that, my lord, I'll complete this area, my lord. The Arbitration Act, Stamp Act, and the Contract Act.
Bhandari in what?
My lord, in an arbitration application, his lordship, my lord, for a second, your lordship.
If you don't mind, complete your submission in examining how to all the three acts can be harmonized.
Yes, ma'am.
Then come to judgment.
Yes.
Let us know from you what is your vision.
Yes, ma'am. My respectful submission is, my lord, arbitration agreement, section 2. B is the arbitration agreement means an agreement referred to in section 7. Now, my lord, I'll take your lordships to section 7. Arbitration agreement means an agreement by the parties to submit to our arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration agreement shall be in writing. An arbitration.
Where are you reading that, Mr. Reddy? There is an arbitration agreement can consist of
Yes, my lord.
a bunch of correspondence
Yes.
from which you can.
So, my lord, it is
I think that we
it
agree.
is so, my lord, it is prima facie valid agreement under the Arbitration Act.
Which one?
And any document, my lord, that complies with section 7.
Okay.
It is valid.
Ah.
Now I take your lordships to the Contract Act.
Because the agreement is in writing, a fait accompli is there.
Yes,
There,
it is.
so the court
It
should
is
be-
valid. No, my lord, it is valid under the Arbitration Act.
Supposing it is between a minor, an agreement is entered into between a minor, it is demonstrated under section in 11.
Yes.
That is a minor, you already admitted. Should the court act on it?
No, my lord, your lordship may have a look at the
Will
contract.
it be a contract?
It will be an agreement, my lord. it goes before the arbitration, my lord.
Yeah.
Your lordship may have a look at the Contract Act, my lord. 2G. An agreement not enforceable by law is said to be void, my lord. An agreement that is valid, my lord.
So there, now that you have touched upon it,
Yes.
17. Section 17 says that it should be stamped before and at the time of execution.
Yes, ma'am.
It is not, in a particular case, no
Yes.
stamp is given. We
Yes,
take that example.
yes,
It is unstamped.
yes.
Can that be said to be enforceable in law? Can you go take that to a court and ask the court to act on it and give relief? This is a question we are putting it to you. Frankly, you have to answer it.
I'll answer it, ma'am. My respectful submission is, my lord, 2G, an agreement not enforceable law is said to be void. Now, my lord, this agreement is an agreement under the Arbitration Act. Now, section 17,
This is an agreement under Contract Act
yes,
put it into arbitration law.
yes, yes.
There cannot be separate agreement under Arbitration Act.
No, my lord, then Arbitration Act will become unenforceable at all if it has to be. My lord, the whole purpose and reason for having Arbitration Act will be lost
Enforcement of
if,
Contract Act.
if an applicant is sent for impounding, my lord, under the Stamp Act, the whole purpose and intent for having this.
We follow your line of argument.
Yes.
Yes. Next, what is your point?
That's one point, my lord. Your lordship may have a look at another aspect. Page 88, my lord. Page 69, my lord. At page 85, my lord.
Yeah.
Paragraph 54, my lord.
Yeah.
As I mentioned below, one of the main objects, paragraph 55, my lord.
Page 84.
Page 85,
Yeah.
paragraph 55, my lord.
Yeah.
Second, the plain language of section 7 once again governs my conclusion. Section 7 does not require that the parties stamp the agreement. It would be incorrect to disturb Parliament's intention when it is so clearly stated and when it is in no way conflicts with the Constitution. 57, my lord. Fourth, section 7(4)(b) states that an agreement is in writing if it is contained in an exchange of letters, telex, telegrams, or other means of telecommunication which provide a record of agreement. Then, my lord, paragraph 59. The court has to translate the legislative intention, especially when viewed in the light of one of the Act's main objectives, to minimize the supervisory role of the courts in arbitral process. Statements of objects and reasons in section 4 of the Act. If the court adds a number of extra requirements such as stamps, seals, and originals, we would be enhancing our role, not minimizing it. Moreover, the cost of doing business would increase. It takes time to implement such formalities. What is even more worrisome is that the parties' intention to arbitrate would be foiled by formality. Such a stance would run counter to very idea of arbitration, where tribunals all over the world generally bend over backwards to ensure that the parties' intention to arbitrate is upheld. Adding technicalities disturb the parties' autonomy of will. In my lord, next para, technicalities like stamps, seals, and even signatures are red tape that have to be removed before the parties can get what they really want. An efficient, effective, and potentially cheap resolution of their dispute. Then, my lord, the maxim autonomy de la volonté doctrine is enshrined in the policy objectives of the United Nations Commission on International Trade Law, UNCITRAL Model Law, and International Commercial Arbitration 1985, on which our Arbitration Act is based. The courts must implement legislative intention. It would be improper and undesirable for the courts to add a number of extra formalities not envisaged by the legislation. The court's
So
direction.
technicalities, stamping is said to be a technicality. Court should get rid of it.
Technicalities in the sense, my lord, while putting the machinery under the Arbitration Act in motion, my lord, the
Yeah.
machinery under the Stamp Act can be taken care of. My lord, machinery under section 11 can be initiated subject to, my lord,
invoking the machinery under the Stamp Act. Then, my lord, your lordship may have a look at page 100, my lord. Commissioner Income Tax versus Hindustan Bulk Carrier.
Yeah.
It starts at page 100, my lord. At 106, 116, my lord.
Yeah.
116. Paragraph 14, man. Your lordship got it. A
We have
construction,
got it. We have got it.
a construction which reduces the statutory futility has to be avoided. A statute or any enacting provision therein must be so construed as to make it effective and operative on the principle expressed in the maxim. Liberal construction should be put upon written instruments so as to uphold them, if possible, and carry into effect the intention of the parties. Then, my lord, para 68. The courts will have to reject the construction which will defeat the plain intention of the legislature, even though there may be some inexecuted in the language used. Para 70. If the choice is between two interpretations, the narrower of which would fail to achieve the manifest purpose of the legislation, we should avoid the construction which would reduce the legislation to futility and should rather accept the bolder construction based on the view that Parliament would legislate only for the purpose of bringing about an effective result. The statute must be read as a whole, and one provision of the Act should be construed with reference to other provisions in the same Act so as to make it consistent with the whole statute. The court must ascertain the intention of the legislature by directing the attention whenever, para 20, whenever it is possible to do so, it must be done to construe the provisions which appear to conflict so that they harmonize. It should not be lightly.
Have you come across any judgment
Yes.
where there is a discussion of Contract Act, Stamp Act, and the Arbitration Act
No.
together?
Only Garwari.
Only Garwal.
Only Garwari is there.
Only Gandhi. But my respectful submission is, my lord.
Because this is Bhandari's order which you are citing.
Yes.
It is in reference to a concluded contract. Parties have.
Yes. Yes. Yes.
There is no concluded contract.
Yes, my lord.
So where you asking for us to go for arbitration?
Yes.
Only in that context.
That context.
arbitration
Yes.
is made.
Yes. My lord, only intention behind having
That's
the
correct. That's
arbitration.
correct. That's correct.
My lord, page 69, my lord, for a second. My lord, with respect to section 7 of the arbitration.
Page 69.
Page 69, ma'am.
69.
69 in your one.
69 you have already read. Section 7.
Yes.
That you have understood. There is offshore.
One.
Same.
Yes.
That you have concluded.
Yes. Yes. Ma'am.
Which is the other one?
Page 147, my lord. My lord, this is also as regards the when special act and general law, my lord. Then the other one is, my lord, Queen's bench, my lord, on harmonious construction.
Mr. Reddy, for stamp law, for stamp act, which is a special law? Stamp act or the arbitration act?
Arbitration Act. And Stamp Act applies to
If a
everything.
document is to be instrumented with stamp.
Yes.
Stamp law is a special act or the arbitration act?
Then it comes special act, my lord. Both are special, my lord. And if
You are right, both are special.
Yes.
Now, who is special over, who is special is.
actually, my lord, it has to be harmonious construction, my lord.
In the latest special law.
Yes, ma'am. Yes. And my lord, just one section, my lord, of the Arbitration Act.
What has happened in the main case? The facts of the case, what is the, you are saying something?
Yes, sir.
Finally, it should not happen when we decide everything.
My bank guarantee stands encashed.
Encashed.
Stamp duty has been paid. We have appointed a arbitrator, Honorable Justice Postponement. Nonetheless, disclosure section 12, I believe, is awaited.
Oh.
Because now my claim is that the bank guarantee should not have been encashed. I did not do any work. That issue was this. But since there's a timeline issue, may I just point out one thing? The timeline was.
I'll just,
Let him complete it.
my lord, section 5 of the, my lord, Arbitration Act, your lordships have already.
Minimal interference.
Minimal interference. Then, my lord, section 28, my lord, I think it's of the Indian Contract Act. This is, my lord, the savings clause as
Contract.
regards the agreement.
Legal
Agreements
proceedings will be void.
void. My lord, it says, saving of contract to refer to arbitration disputes that may arise. This section will not render illegal a contract by which two or more persons agree any dispute that may arise between in respect of any subject or class of subjects so and so to be referred to arbitration. Then, my lord, another saving clause, nor shall this section render anything illegal, any contract in writing by which two or more persons agree to refer to arbitration, any question between them so and so. So my respectful submission, my lord, harmonious construction has to be done. And my lord, section 11 application can be entertained, my lord, and referred to the arbitrator. That's my submission.
Thank you. Great. So anybody else is there? So that we finally ask the amicus to wind up.
I can have your lordship's leave to address your lordship very short. Let's just.
Very short.
Yes, very short. Just a few points, Millards, and I'll make sure I
Who
don't.
are you? What are you?
Millards, I'm one of the
Never
interveners. Millards, I'm one of the interveners.
Or intervene.
Yes, Millards. And Millards, my respectful endeavor would be that without repeating anything that has been urged before you, just on interpretation, just to take your lordships that how do you connect the dots under the act, and 2 or 3 judgments where
Just give us your intervention application first.
Millards, IA 19969 of 2022.
Give that application.
One other thing, Mulon, my learned friend is Mr. Gagan Sanghi, not Mr. Goel.
Sorry?
Mr. Sanghi. He's not Mr. Goel, Mulon.
He's Sankey.
He's Sanghi. I just wanted to add it back.
Gagan Sanghi.
Gagan Sanghi.
You get signed.
We have called you Goel because your compilation say Goel.
That's it.
Millards, very simply, in my case, what has happened is SMS was relied upon.
What is your name? So we.
Millards, Debesh Panda. Millards, I am the advocate on record. Debesh Panda.
Uh,
Debesh Panda.
okay, the name is here.
Yes, Millards. I am the advocate on record.
Good.
Yes.
I don't think.
Yes. So, Millards, in my case, very simply put, Millards, SMST is relied upon, and my arbitration agreement has been invalidated today because stamp duty was not paid. That's a judgment, Millards, and I'm challenging that. Millards, and that is pending before your lordship.
Invalidated means what?
Invalidated meaning, Millards, at the stage of 11.6, which I filed,
Correct.
I was asked, why have you not paid stamp duty on it? I took a stand in the High Court that no, this document is not required to be stamped because it is an agreement to lease, not a lease. That came before your lordships, the order of the High Court, and your lordships reversed that view, saying no, we feel it is a lease deed. But at the end of the day, relying on stamp deed, my arbitration agreement got invalidated completely. I am challenging that, saying you cannot invalidate the clause. I am ready to deposit it if your lordships requires under protest and without prejudice. But if this question is ultimately decided one way or the other, yes,
That's why we asked you whether it's invalidated or.
it is invalidated. That's the difficulty. It's not impounded. It is invalidated. That is why I am, my lords, before your lordships,
You're before. This means
in a curative. In a curative, saying now that the question is finally being decided by your lordships as to whether it is invalidated or it is merely to be impounded and is curative, if your lordships holds in this in one way, which is in my favor, it will have a bearing on that petition there. And my lords, what has happened in my case is SMST is squarely relied upon to say this covers the issue. The agreement stands invalidated because stamp duty was not paid. So, my lords, with that preface, my lords, very quickly because I see I don't have much time here. Well, this is a simple case where I see of an intersection of the Stamp Act with the Arbitration Act that is taking place. This intersection, Mallards, in my respectful submission, I have the note. Because what I'll do is I've made a very small note to assist your lordships.
Because what I've done is I've tried to condense everything into very simple propositions. And I can just take your lordship through that itself. So, well, the questions that are referred to your lordships, I will briefly say they fall into two broad categories. Category 1 is para 146 and 147 of Vidyadrolya, where basically what happens is existence and validity have been equated, if I may say, my lords, very broadly. The second yes, well, lords, first part of the reference to your lordships is Vidyadrolya, wherein existence is equated with validity, is doubted, and that is referred to your lordships. And that, my lords, I say, and I am supporting the amicus on this, that existence is not equal to validity. The two have to be given a separate meaning. This is one. Two, in the context of certain judgments pertaining to section 8 and section 11, their correctness is doubted so far as a temporary affliction created by the stamp duty is concerned. That is separately referred to your lordships. So there are two aspects of the reference to your lordships. Yes. So, well, if I may briefly segregate them, these will fall into two categories. Category 1, I would say, my lords, is provisions which are falling under part 1 of the Act, which is 8, 11, and if I may add absolutely at the end, section 9, which your lordships will take a view whether it will form a part of the reference or not, and I would say, my lords, it should be left open. And the second category, my lords, is section 45, which is under part 2 of the Act. Yeah. Now, my lords, before I begin, one brief point which I would say, my lords, is in a way of speaking a vantage point from which your lordships can see the Act. Your lordship may look at the fact that the Arbitration Act is a consolidating legislation which is in two parts. Part 1 is supposed to be taken from the UNCITRAL model law. Part 2, on the other hand, my lords, with utmost respect, is India's international law obligation under the New York Convention. There are certain provisions, there are certain expressions, if I may use the expression, phraseology that is employed in the convention. India ascended to that convention. It ratified it in 1960 through our parliament. So we have a bounden obligation in international law that we have to give effect to what the convention says through our domestic law. And this, my lords, according to me, has a bearing on the question before your lordships, because how 45 will be interpreted will have to take into consideration that we have to follow the New York Convention. And the New York Convention gives the expression under Article 2, Sub-Article 3. That your lordships will find under the Act. Kindly take up the first schedule to the Act. So, lordship sees the Arbitration and Conciliation Act.
This whole question, but how is this issue of
stamping
of New York Convention?
It is, well, all I'm saying is your lordship will bear with me for about 10 minutes and it will squarely answer the question before you, is how I'm putting it. But question, I need to start somewhere in the Act, and I want to start in my own way, Malad, from section 45, because I'll take this as a reference point in the Act which has not changed. Everything else Parliament has been changing. I will show your lordships those amendments. I will show the departure in the language, and my submission would be, if the departure in the language is to be respected, then Malad, your lordship will have to give meaning to the Arbitration and Conciliation Act the way Parliament is repeatedly amending the Act and giving a hint saying, please do this, please don't do that.
You want us to understand the trend of the parliamentary amendments.
I want
on that basis interpret.
I want to give meaning. I want to give meaning to the expression existence and validity used in 8 and 11. Yes. So, all I am doing is, I'm only taking reference from section 45 to begin my argument. So, if your lordships will see the first schedule to the Arbitration and Conciliation Act. And this, my lords, in international law, we call this hard law, because once you assent to a convention, you assume an obligation as a country that you will give effect to what you have agreed to. We've ascended to the New York Convention since 1960. We have an obligation to give meaning to the New York Convention. But
I mean, through your municipal law.
Through my municipal law. But when it comes to part 1 of the Act, It is an UNCITRAL model law of 1985, which means it's a soft law. It's a model. You choose, do you want to adopt it? Do you want to depart from it? There is some elbow room that you have as a country. We have utilized that elbow room to make departures. I want to show those departures to say that will have a bearing on what your lordships is answering as a constitutional bench. In fact, it may completely answer it. So, my lords, with utmost respect, lordship will take up the first schedule to the Act, the New York Convention. Lordship has that? Yeah. If your lordships will see Article 2, Sub-Article 3.
Yes.
Kindly see the expression, my lords. Shall at the request of one of the parties refer to the parties to arbitration unless it finds that the said agreement is null and void, inoperative and incapable of being performed. So, my lords, if I may say this, when we began with a clean slate, we borrowed a language used in a convention saying null and void, inoperative and incapable of being performed. Now, that your lordships will find is mirrored in section 45 of the Act, part 2. We had an international law obligation, we have followed the obligation. What we have in fact done, my lords, we've gone a step further.
55 is the
Pardon me, my lords?
execution of an award.
So part 2, my lords, if I will say use this, so suppose there is a proceeding, my lords, how 45 starts applying is it's not in the context of execution of an award. 45 is a corresponding obligation to section 8. To section 8. A very simple example, my lords, and this happens regularly. Some NCLT proceeding would have been initiated saying oppression and mismanagement. Absolutely at the end of the NCLT proceeding, a 45 will get filed by one of the parties who is an international entity to say, no, this is arbitrable, first send it to arbitration. This is how it practically happens, madam. My respectful submission is, part 2, yes, is on for an award, but the New York Convention itself contains a provision for the arbitration agreement. So when you're looking at it as a clean slate for a question of interpretation, a good starting point is section 45. In 45, your lordships will see para 7 of my note. I have identified that when we made the law, we went a little further than the New York Convention. New York Convention said refer the parties to arbitration. We've added an expression that saying or any person claiming through or under him. So we are trying to take the object and purpose of the convention one step ahead so that if somebody is not a party but is claiming through him, a non-signatory, my lords, his right is not defeated. Why this becomes important, my lords, is when your lordships interpreted 45 in Shinetsu, and that is your lordship judgment at 2005 volume 7 SCC 234, this question arose. This exact thing what your lordships is examining today, existence, validity. Because stamp, my lords, is the second part of the reference. I'm on the first part of the reference, para 146, 147 of Vidyadrulya. This same issue arose. How do we decide whether an agreement is null and void, inoperative or incapable of being performed? And why I am referring to this here is, would your lordships for a minute come back to section 8?
Before we do all that,
Yes.
you'd like to just understand.
Yes, ma'am.
You're defending the suit.
Absolutely.
By the section 8 or 11.
My lords.
Correct. The matter was referred to the arbitrator.
Quite right.
Correct.
Quite
It
right.
was challenged by the plaintiff.
Quite right.
This court set aside the order passed under
Quite
section
right.
11.
Quite right.
Kindly come to page 27 of your compilation. Not that we are sitting in judgment of.
No, my lords. If your lordships is asking me on the finding in equity.
No, not in equity. We are
Yes.
just asking you something else.
My lords, page 20.
This is prior to say. See, here what are we considering? Here we are considering the effect of section 6A.
One of the questions. 8 also is in question, my lords.
Right.
Yes.
6A. 8 also is amended along with.
On the facts of my case, my lords, I'll bow down. Your lordships is right. It is anterior to that. It is anterior.
And
Yes.
they followed SMS.
I bow down, my
At
lords.
page 27.
I bow down.
In the case where it was referred to the registrar who found the stamp to be 1 crore.
I bow down, my lords. No, my lords. In fact, in this court, I had also offered to pay. That is also on record. I placed on record. But so all I'm requesting is, just permit me, my lords, 20 minutes of indulgence.
We thought that it was invalidating, not invalidating. The court actually appointed somebody The stamp duty was
Yes.
determined, you refused to pay.
And before this court, thereafter, there is an order where I offered to also pay. That was in the High Court. I bowed down. I bowed down. So, all I'm saying is, may I just have your Lordship's indulgence for about 15-20 minutes just to point out some things on interpretation. I'm not getting at all into anything on facts. Perhaps it may assist your Lordships on a question of law. I'm not getting into the underlying issue at all.
What new can you contribute?
Yes, that is all. That is all. I'm only contributing on interpretation.
You are not really affected at all.
Absolutely. I will just contribute interpretation and leave it at that. If your Lordship feels that there is something that your Lordship is answering the reference and this assists your Lordship, just consider it is all I'll request. 15 minutes. Yes. So all I'm saying is if your Lordship sees section 8, because that was one of the issues that your Lordships has been looking at, the language is similar. 245. The language here is refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Now, one of the questions that arose was, how do we do that? Do we go by the SBP approach that we finally decide, or is it done on affidavits? My respectful submission, and this is my first submission, 45 employs the same phraseology unless it finds. It didn't even say prima facie. Your Lordships interpreted it in Shinetsu to say, let it be prima facie so it can go to the tribunal. In that, that judgment is very interesting because one opinion was of Justice Sabharwal, who took the orthodox view saying, no, it has to be decided, there has to be a full-scale trial. Justice Sri Krishna said, no. And then Justice Dharmadhikari said, I agree with Justice Sri Krishna, but with one more caveat that I am adding. My respectful submission is on interpretation of 8. The advantage that your Lordships has today, when you are interpreting the Act as it stands today, 45 uses the expression prima facie, 8 also says prima facie. 8, my lords, this will have a bearing because in a way it is an indicia of the fact that take the Shinetsu approach. So my respect, and I'm only, my lords, I'm not getting into anything on underlying facts. I'm just assisting on interpretation to say one way out of this complication is to say your Lordships is just taking a prima facie view. I'm not right now addressing your Lordships on stamp. I'm on existence and validity. When your Lordships is looking at, there is, and the language under 8 is, unless it finds that prima facie no valid arbitration agreement exists. 2 expressions are there. Arbitration agreement exists. Prima facie, is it valid? My respectful submission is, your Lordships would examine Shinetsu, and if it comments itself to your Lordships, because that has withstood the test of time under 45. At the time when your Lordships interpreted in Shinetsu 45, you didn't even have prima facie as an expression there. It's come in later. But today when you're looking at 8, you have the benefit of the expression prima facie.
In fact, in the SPB,
yes,
paragraph 12, the court said that once the 11th court decides, not open under section 16.
Which is why, Malad, the basis is being taken away by amending.
That has been taken away.
Yes.
And if you see the Law Commission report,
yes,
they have referred to that judgment.
Absolutely.
And so that regime is now being followed. There is no difficulty about that.
All
what we are saying is, supposing a document is unstamped or it is inceptionally stamped, a different law provides for a regime.
I'm sorry, Malad, then I'll just clarify. I'm not addressing this for the purpose of only stamp duty.
We are concerned only with stamp duty.
I am only on the fact that
para 146.
Yes. So when your Lordship says
of Drolier
and para 146, I'm only on the and part because what Vidya Drolier does is it says, referring to Garware wall ropes, that existence and validity are one and the same. I am only showing my lords. Let me take you through the amendments to the Act, and I began with 45 to say, when you had a clean slate, unless it finds it as null and void, inoperative, incapable of being performed, at that time there was some wisdom in 2007 that your Lordship said, no, let it be prima facie. And there was a contrary view saying, let there be a full-on trial on evidence, and your Lordships disagreed with that. And I think there is some wisdom in that approach, my lords, in saying keep it prima facie, especially when today your Lordships is interpreting section 8, having the benefit of the expression prima facie in it. So this is my first submission. Now, my lords, second point is, your Lordships is looking at what is null and void, inoperative or incapable of being performed. In 2016, volume 8 SEC 813, this is at para 11 of my note, I have pointed out for your Lordship's assistance that your Lordships have already taken a view that if in any way it pertains to legality and validity of the substantive contract, we will not extend the consideration under 45. That is your lordship's judgment in Sasan power. Paras 49 and 50. So I am saying your lordships may take the benefit of what your lordships has already formulated as a view under 45. It will be an aid when your lordships is looking at section 8. That's all. So I'll just give bullet points to that. This is point number 2. 3, my lords, and this is Hindustan Steel. Your lordships has already heard it at length that it is not supposed to give one litigant an advantage over the other. You're just taking care of a temporary affliction because now the simple argument, my lords, is if a temporary affliction like this cannot render the substantive contract null and void, and I'm on the test under 45. The test under 45 is it has to be null and void, inoperative or incapable of being performed. If a temporary affliction like...
What is your understanding of the word enforceability?
Yes, and I'm answering that.
And you can answer it after that because it's already one. You've got it.
Very
Itself.
Very true. Look, may I complete?
10 minutes.
Yes, my lords.
And half an hour, and 3 o'clock we'll start the other one.
Yes, my lords. So 2 points, my lords, as I will be addressing your lordships today
By the clock. Huh?
by the clock. 2 broad submissions. The first submission I was on, my lords, is on 8. How is 8 to be understood?
Yeah.
The second point that I will be making later on, my lords, is on how the Act being a complete code, Section 5 will come to the aid of a judicial authority when confronted with an objection raised on the basis of a document being unstamped or inadequately stamped. So 2 submissions that I'm making. The first submission, my lord, I was making before lunch, my lords. I was using Section 45 to show you how 8, my lords, is a departure, and therefore there has to be specific meaning given to the departure made by Parliament. 2 submissions that I made, my lords, prior to lunch. 1, 45 in its original avatar was drawn from the New York Convention. In 45, my lords, when your lordships were looking at it, your lordships in Shinetsu interpreted unless it finds to be a prima facie determination. It did not require an elaborate trial, although that point of view was canvassed by one of the opinions, but that is the minority opinion of your lordships. The majority opinion, it preferred a prima facie determination. Now, when that was a view that your lordships took in 2007, when Section 45 did not even have the expression prima facie, today your lordships has the benefit of the expression prima facie in Section 8. It is all the more reason that your lordships will adopt the Shinetsu approach when your lordships looks at Section 8. This is one. Second point, my lords, would your lordships take up Section 8 in the bare act? In the bare text, kindly see in the footnote to 8 is how 8 originally was when the act was enacted. And this, my lords, is very interesting because under Part 1 of the law, when we made the provisions, we were supposed to draw inspiration from the UNCITRAL model law. In UNCITRAL model law, Article 8 mirrored Article 2, Sub-Article 3 of the New York Convention. They had the same expression, null and void, inoperative, or incapable of being performed. When Parliament enacted 8, it completely discarded that expression. There was no exception for a judicial authority. Kindly see the footnote to my lord, Section 8. This was the provision as it originally stood. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party so applies no later than submitting his first statement on the subject of, refer the parties to arbitration. There is no exception. The exception was in the UNCITRAL model law. Unless it is null and void, inoperative, or incapable of being performed. So, my lords, from one extreme, which is under the UNCITRAL model law, when Parliament made Section 8 originally, it travelled to the other extreme, saying we will not allow any exceptions. There is a judgment, my lords, of your lordships called Anand Gajapati, my lords, Anand Gajapati Raju, 2000, Volume 4, SCC 539. Where in view of this, what your lordships interpreted and held was, Section 8 is peremptory. If a reference is made relying upon Section 5 read with Section 8, your lordship's view was, it is peremptory. If a request is made, you shall refer. There were absolutely no exceptions under 8. Now, my lords, what now has happened is in 2015, a middle path is now taken by Parliament. So Parliament could have said, we will adopt bodily null and void, inoperative, incapable of being performed. It didn't. It made it peremptory. Now it says, unless it finds that prima facie no valid arbitration agreement exists. So it's a middle path. Now, my lord, the choice of expression in the middle path is the next thing that I want to emphasize on. Parliament is aware in Part 2 of the legislation it has used of phraseology, but in Part 1 it is deliberately now using only one expression, validity. No valid arbitration agreement exists. So it's aware that an arbitration agreement may be existing, but the judicial authority is bidden to give a prima facie examination to validity. Now, why I say this, my lords, with utmost respect, Parliament under Section 8 now, post 2015, is aligning it with section 16, because section 18 also uses the same expressions, existence and validity. Once Parliament is saying under section 8 as it now exists, prima facie, please see, prima facie no valid arbitration agreement exists, and then 16 always has existed, where a tribunal can, exercising competence, look at existence or validity. The scheme is very clear. In 8, please make a prima facie determination, leave the rest to the tribunal. What is, my lords, to be additionally noted is two aspects. Section 45 begins with a non-obstante clause. So 45 requires your lordships to not be colored by anything in part 1. Notwithstanding anything in part 1 or the CPC. That's how section 45 opens. So when your lordships is interpreting null and void, inoperative or incapable of being performed, they are standalone. They cannot take strength from the other provisions used in part 1. Why this is important, my lords, is, now take, my lords, a situation at hand which is a temporary affliction because of stamp duty. Now, my lords, on a plain reading of the scheme of the Act, it does not destroy the document. It's a temporary affliction.
It is a temporary, what do you call it?
Affliction.
Affliction.
Affliction, my lords.
You violate the law and you call it temporary affliction.
No, my lords, for the reason that the Act itself says, the Act, and as your lordships have interpreted the Act, in Hindustan Steel, the expression used is, Act is a fiscal measure enacted to secure revenue for a state on certain classes.
Unstamped document which you described as a temporary affliction.
For the reason, my lords.
Engage the attention of a civil court.
Yes.
And the civil judge.
My lords.
Sees that it is not stamped.
My lords.
What is his duty?
Yes, my lords. I'll address my lords. I'll address my lords.
A temporary affliction.
I'll address my
if
lords.
the stamp duty is not paid.
I'll take several parallel illustrations.
All within 2 minutes.
Then, yes, parallel illustrations. Illustration 1. Illustration 1. And I'm on 45. Kindly see your lordship's judgment in Vijay Karya.
45, we are not concerned with 45.
For the reason, my lords, I'm on a better footing there, so 8 can't be worse.
We are talking about 11. We are not
Very well.
8 even. We are on 11.
On 11, my lords, yes. The answer is much narrower. The answer will be, if it is a rectifiable breach, your lordships in several judgments have indicated that that will not stand in the way when your lordships has to grant relief. One citation, my lords, is 2020 volume 11 SCC 1. Here, 2020 volume 11 SCC 1. Vijay Karya. That was under 48. The rectifiable, your lordships characterized it as a rectifiable breach. What? RBI approval was not taken and FEMA was being violated. And they said, you can't enforce this award today. Now, my lords, your lordship put to me, you violate the law and then you call it an affliction. My lords, somebody takes an award and it's violating FEMA. Your lordships have treated it, have characterized it as a rectifiable breach and said, this cannot stand in the way of enforcement of an award. So, my lords, when the expression is null and void, inoperative, incapable, my respectful submission is only this. A temporary affliction, a rectifiable breach would fall outside the sweep. It has to be something more. It has to be something permanent that attaches. Otherwise, my lords, it will not come within the sweep.
Enforceable till it is stamped.
Which is the second argument. Now, my lords, that brings me to the second argument in my note that starts at para 45. My lords, my submission is your lordships will see 3 aspects together. 1, in a series of judgments, your lordships have held that the Arbitration Act is a complete code. As to what is the connotation once a law is held to be a complete code, how it excludes the operations of other laws. There are several judgments I've reproduced in my note to assist your lordships. My respectful submission is, A, the Arbitration Act is a complete code. B, the Arbitration Act in Part 1, Section 11 falls under Part 1, has Section 5. In Section 5, Parliament has gone one step beyond the model law by adding a further non-obstante clause which says, notwithstanding anything contained in any other law for the time being in force. So Parliament is conscious there will be laws like the Stamp Act. Parliament is saying, I am making a complete code. I could have borrowed lock, stock and barrel Article 5 of the UNCITRAL model law which didn't have a non-obstante clause. It will create a problem because laws like the Stamp Act exist. Let me therefore add an additional layer of protection. And what is the text of Article 5? I beseech your lordships to see Article 5. Section 5, extent of judicial intervention. My respectful submission, my lords, is impounding a stamped document is also an intervention. It is an intervention by a judicial authority. The language is
No,
not.
ultimately, is it your argument that if stamp is not paid
My lords.
and the document is brought to the court,
Yes, my lords.
so court will refrain from
Two submissions, my lords.
impounding
Two submissions.
because the act says minimum judicial intervention.
Two
Is
submissions,
that
my
your
lords.
submission?
Two submissions, my lords, on that. Number one, at the stage of section 11.
No, forget at the stage.
Yes.
Whether
I bow down. What your lordships is asking, I'm
level of
answering
judicial
that.
intervention.
Yes.
We are on
So, my lords,
judicial
my answer is without pitching it beyond the level, because that would be pitching it, my lords, beyond what I'm trying to. I'll pitch it a little lower to say, as and when your lordships is exercising power under 8 or 11, it is judicial intervention, and the language of 5 is very clear. Notwithstanding anything contained in any other law for the time
It
being.
cannot be judicial intervention in the first place. It's something through the judiciary.
Call it through the judiciary. In matters governed by this part, no judicial authority shall intervene except where so provided. My argument is so provided. What your lordships is asking, my lords, would be, I would be going beyond so provided. If your lordship gives meaning to the expression so provided, my respectful.
Section 37, section 34, these are what is contemplated by so provided. It is very clear.
Yes. So, my lords,
So
therefore.
that don't, beyond that, no.
Quite right. So,
right.
if at the
Some
stage.
say that when an application to section 11 is filed, I mean, there is a question of interference there.
Well, that's for the reason, if
court is passing an order of refusing to pass an order based on the facts.
If your lordships, then my respectful submission is, suppose your lordships were to say that there is a Stamp Act obligation and we are enforcing it, your lordships would be traveling beyond section 5 is my respectful submission, because the non-obstacle clause becomes redundant.
You understood.
This
What is
because-
the next point? Yes.
Yes.
Intervention in arbitration.
Intervention in arbitration creates the problem. That's all.
11(6)(a).
Yes, my lords.
If it is found that no, there exists no arbitration agreement at all,
My lords,
how can you say that it is an interference with arbitration? There is no question of arbitration.
because my lords, the power that is, I would only say the
So
power
section
is.
5 says about intervention in arbitration.
My lords,
See, at 11(6)(a), what is the question to be decided?
quite right.
Once it is found that an arbitration agreement exists, then only the question of arbitration would come.
In your lordships, the answer to that, my
So
lords,
can
would
you
be-
say that that intervention, the word intervention, it means that the court cannot go into that question under 11(6)(a)?
all I'm saying is the intervention, since it is happening once power under 11 has been invoked, it would go beyond so provided. That's all. And my lords, my respectful submission is, I have given certain citations. Kindly see, my lords, in my note at para 53. I'm only giving the citation. My lords, I'm not going further beyond that. Para 50, I have given judgments on section 5. 53, other judgments, like for example, in an election trial, your lordships have held when an election trial is conducted, we don't go to the CPC because it creates a problem. So I have given different illustrations of different acts when they are held to be a complete code and some other law is brought in and it creates a difficulty. Your lordships then says, since it is a complete code, we will not allow that to interfere in the working of this law. So Malad, those citations are at para 53. I have given examples of the Income Tax Act. I have given examples of election trials under Representation of People's Act. I have given judgments, my lords, separately. There's a local Calcutta law, for example, my lords, under 1993. I have also given example of the IBC. When IBC, my lords, your lordship is trying to do a corporate insolvency resolution process, so many laws start coming in the way. But your
arbitration award, is it to be stamped?
No, my lord, there's a judgment of the Rio Glass. Foreign awards are not to be stamped.
You're talking about Indian award.
Indian award.
You are full of your.
No, my lord.
Foreign awards.
No, they're required to be. I misunderstood.
Required to be stamped.
Yes, my lords.
So the example we are putting to you is, suppose if there is an award passed.
My lords.
It is not stamped.
My lords.
It is put to execution. So it's a decree.
Quite right.
Without anything to be done.
Quite right.
Will the executing court be bound to execute?
My lords,
Or will it say section 5 we will not interfere? Judicial interference means we have to execute it.
Well, that's what I would respectfully submit. What I would respectfully submit is the executing court would strike a balance. It would ask the entity who is seeking execution that do you want to secure it? But it will not say I will not do, because my lord, there may be a worse problem.
stamp back therefore applies.
Milaz, I am not for a minute saying,
You are
I am saying
saying
your
in the
lordship.
beginning that
Milaz, that's why I responded to the
not-
question saying, I am not pitching it so high to say the act doesn't apply. I pitched it lower to say, I don't want to pitch it so
Minimal
high.
interference.
Your lordships will modulate using section
We'll do
5
that.
and the non-obstante clause.
Bound to do that. We'll do
Your lordship will modulate. So, Milaz, which brings me to the last point, which is for Ashok traders, which is yesterday when your lordship were rising, I had pointed it out, that judgment. Milaz, that is also an example of a rectifiable breach. That was a case where section 9 was filed. The entire section 9 was sought to be defeated.
Section?
Milaz, that is 2004 volume 3 SCC 155.
155.
Now, Milaz, there, para 13 of that judgment, section 69(2) of the Partnership Act is relied upon. They say this is a partnership deed. You are seeking interim measures arising out of a partnership deed. Sorry, the deed is not registered. We will not come to you. Court cannot come to the aid of the litigant. Court said doesn't matter. At the end of the day, since it is 9, we can extract the arbitration clause and look at it by itself without getting fettered by the underlying document. Otherwise, somebody's right to relief gets defeated. So, Malad, all I'm saying is whether it is Vijay Karya, whether it is Firm Ashok Traders, whether it is Shinetsu, there are, Malads, parallels that are there in the law. And Malads, your lordship will also bear in mind another example only, and that Malads is 1996, volume 6, SCC 660. Rectifiable breach or curable affliction, if I may say. Suppose a plaint is lodged in a manner where somebody is not authorized. Your lordships have carved out a distinction in that judgment to say you cannot ensure substantive rights are defeated and no injustice is done. So your lordships have said, we'll allow you to cure it, but it won't stand in the grant of relief. All that I am submitting, my lords, therefore, is section 5 and the complete code argument can possibly give a middle way out.
Thank you.
Grateful.
Yes. Now, whatever you have to say, Gaurav, we are looking forward to your.
My lord,
Mr. Banerjee, what am I trust? We've heard one side of the argument.
my lord, I just want to emphasize only 2 points. My lord.
Yeah,
One is 2G, something your lordships wanted some
that's right.
2G. And secondly, my lord, what is falling from the benches, arbitration is great, arbitration is good. We must, my lord, certainly, my lord, help it along, make the appointments. But why are we doing this by violating the law? This is the point which is troubling your lordships. Are you violating, is the section 11 judge violating the Stamp Act by not impounding the instrument at the section 11 stage? My lord, the argument on the other side is a little circular. You can't violate the law. The Stamp Act is the law. You are violating the Stamp Act. You cannot do it. My lord, therefore, the predicate question is, are you violating the Stamp Act at the 11th stage or not? Everybody has assumed, my lord, that you are violating the Stamp Act at the 11th stage. My lord, I'll come to that separately. My lord, I just want to say this. My lord, it is nobody's case that the court has zero role. Nobody's case, my lord, that at the section 11 stage, the court is acting as a post office, my lord. At least it's not my case, and it is not even the legislature's case that the court is acting as a post office. That may be the result, my lord, of the 2019 amendment. Maybe we are going to reach that very quickly. So, my lord, undoubtedly, the court has a role. The question is, what is the extent of the role? This is one point your lordships will have to consider. Secondly, my lord, it is not that somehow by appointing, the court lets go of the matter. My lord, the court has the ultimate supervisory jurisdiction. The arbitration or the arbitrator is not above the court. Ultimate, whichever jurisdiction we go to, the supervisory jurisdiction is always with the court. Well, these are larger issues your lordship will keep in mind. So supervisory jurisdiction is always with the court. I would have submitted, my lord, and this is one aspect your lordships may consider. Otherwise, we'll have another 10 judgments on Article 11, that at the 16th stage, there is intervention under Article 16(3, my lord. That is something your lordships may consider whether the legislature may have a look at it or not. But in any event, my lord, at the 34th stage, the last call assuming, my lord, the arbitrator goes haywire, assuming he acts on an unstamped document, assuming he doesn't hear anybody, etc., the last and conclusive call is always with the nobody is saying that the arbitrator is an errant, can go free anywhere he wants. So, my lord, therefore, the only question is the scope of interference, or I wouldn't use the word interference. No, interference has a negative connotation. Scope of examination at the 11th stage, and whether by in my respectful submission, expanding the examination to include stamp is contemplated under 11.6a or not. That's really the question. As I started, my lord, at the beginning, your lordships can take both. My lord, both views are possible. I had said that right in the beginning. I had also said, my lord, that NN Global was not correct. I had also said, my lord, and I want to address that first, that unfortunately, my lord, neither is Garwari and neither is Vidya Drolia, and the 2G analysis there is simply, my lord, inconsistent with.
What about that SM?
My lord, SMS, there's a different problem. My lord, SMS may be a different problem, but certainly, my lord.
What is your contention?
My lord, I'll come to SMS separately, my lord.
Because
that's
to consider that. Also.
That, my lord, your lordship. So, my lord, there are two questions if I can formulate. One is, what is the answer to the reference? Question number one. Question number two, my lord, I will phrase it like this: whether the issue of examination and impounding of instruments, please note all words here, examination and impounding of instruments should be done by the 11th judge or should be left to the arbitrator. Those are the two questions, my lord, which squarely arise for your lordship's consideration. One, answer the reference. Two, answer whether this examination is to be done by X or Y. Well, there's actually very simple answer on 33, which I have discovered pursuant to what your lordship said yesterday on the scheme, etc., which perhaps, my lord, will cut the Gordian knot, my lord, and maybe give an easier way out of 33 and 35, which may not require, my lord, great mental gymnastics. I'll come to that. There's a simple, my lord, I would say silver bullet, which answers 33 and 35. I'll come to that. Please first see the reference question. So let me, my lord, first deal with the reference question. Yeah. That is a question your lordships have to answer. Can you just hand it over? Lords, I have recast it and there's a reason. Copy. A lot of the issues your lordships have raised are covered in my spiral bound notes. Many of those issues are covered, but anyway. My lord, I have struck out which is not chargeable to payment of stamp duty. That is because, my lord, in my respectful submission, it is even an arbitration agreement is. And my lord, what I have now, there are three phrases which are used in the reference order. One is non-existent. Your lordship see that? Yeah. Non-existent. My lord, existence is a word which is relatable to section 11 and 16. Existence is a statutory word. My lord, I have added, and I will explain the reason for this, unenforceable in law. My lord, the reason I have added this is the expression in 2G. The word, my lord, unenforceable, your lordships will not find in the Arbitration Act. My lord, what your lordships will find in section 45 is incapable of being performed, null and void, inoperative, and incapable of being performed, whether unenforceable is covered by that or not, but that's 45 is your lordship, and nothing to do with it. So, my lord, the phrase I have used is unenforceable.
Where do you get the expression incapable of being performed?
45.
That is in
45. And that, my lord, was deleted. I have said it in my note, my lord, it's deleted. So, my lord, there were three concepts: null and void, which is void; inoperative, different; incapable of being performed, different. World Sports Group, my lord, is there in my note. Each of these have different meanings, three different concepts. So, my lord, is an unstamped document, my lord, is it non-existent? Is it unenforceable in law? Or is it invalid? My lord, I have added the word void because, my lord, invalid, again, validity, I would say is a word which is used, my lord. Valid, my lord, the flip side would be void. My lord, there is no third expression, at least in the Contract Act. My lord, either is void, my lord, voidable we are not.
What is there any procedural impropriety, in this reformulation? Is constitution
My
based?
lord, your lordships will have to I can't see any procedural impropriety, my lord. I mean, subject to.
Yeah,
Sorry? It is, my lord, regularly reformulated, my lord, because ultimately your lordships have to answer the question. The question has to be answered. So, my lord, 3 expressions are there. Now, my lord, what your lordship put to me is the commentary in Mulla, where, my lord, this is mentioned. And please see, my lord, paragraph 22, 29 of Garwade and 146 of Justice Khanna's. My lord, let us please spend 5 minutes because that has some relevance, my lord. I'm sorry to take a little bit of time on that.
Ultimately, it'll boil down to that.
These 3 at least let us see, my lord. And the 33, 35, my lord, I will find a rather simple answer, my lord, maybe simplistic, but a simple answer. I'll come back. Please see these 3 paragraphs. Lord, if your lordship take my compilation 1.
Which 3 judgments were relying
My
on?
lord, I am only looking at 2 judgments, my lord. 2 paragraphs of Garwade and 1.5 paragraphs, my lord, Vidya Golia.
They are in the.
They are, my lord, in my first compilation reference, my lord.
It's there.
It's there, my lord, in every compilation, whichever one your lordship wants to look at.
Keep that.
No, I don't have a copy of their compilation, my lord.
No.
Unfortunately.
Pages may not match.
Pages done. Anyway.
You're getting one.
I'm getting one. But in any case, your lordship, I can coordinate the pages. Please see paragraph 22 of Garwade. That is at page 25 of my compilation.
That's good.
Lord, please read 4 or 5 sentences here carefully without comment I'm reading. Lord, first para 21, 2A, B, G, H is set out. Then please see, when an arbitration clause is contained in a contract, it is significant that the agreement only becomes a contract if it is enforceable by law. Lord, no dispute. Absolutely correct, my lord. No dispute. Agreement, contract, enforceable by law, no problem. Well, the next sentence is the problem. We have seen how under the Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped. My lord, with the greatest of respect, not correct.
Wait.
Why? Right. My lord, please, let's read the sentence. We have seen how under the Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped. My lord, the rationale of this bench is that till I stamp a document, it is only an agreement and not even a contract.
This is exactly.
My lord, this is the issue. Yes.
Bazir does.
Right.
But
now, my lord.
When you see the effect in terms of the enforceability,
my lord,
is
this
to be viewed from the prism.
My lord, this sentence.
What will a litigant do with an agreement which is not stamped if he wants to?
My lord, your lordship,
court of law.
My lord,
there is a point.
That point,
That's
my lord,
therefore
that is weighing, my lord, but my lord, that is not the language of the Contract Act. The Contract Act says enforceable by law if it is not enforceable by law.
Not
if it is not enforceable by law, the consequence is it is void.
That's right.
Now, my lord, the question therefore comes to the point that if there is a agreement which is unstamped, let us leave aside the court for a moment. If it is unstamped and it is an agreement, the day the unstamped agreement is concluded, my lord, namely parties, consideration, etc., it becomes a contract. It is not void, my lord.
There you must bear in mind section 17.
My lord,
the Stamp Act.
My lord, where this distinction comes from, my lord,
Please
your lordship,
section 17.
17, my lord.
Got a bearing on This very issue.
My lord, 17 says, what your lordship says, 17 says that a document should be executed on a particular date. Right, my lord?
No. Can you read section 7?
I'll read
We
7.
have a-
But my lord, this is very, because the consequence,
It's important. What you have raised is very important.
my lord, I want to clarify it. I want to show, my lord, that the Law Commission specifically addressed the issue of stamping
That's right.
and found that 2G operates in a different field. It's a very interesting observation by Mr. Setalwad's Law Commission, my lord, which deals with this issue. I'll show that. 17 is instruments existed in India. All instruments chargeable with duty and executed shall be stamped before or at the time of execution. There's no dispute about it. The question is, what is the consequence of non-stamping? The consequence of non-stamping on day one does not render.
Please read section 62 of the Stand Back Talk.
Lord, 62 is penalty, my lord.
Please read it.
I'll read it, my lord. That is also, my lord, dealt with. I'll show another judgment on 62 also, my lord.
Please read it.
60, my lord, I'm obliged.
Referred to it NM Global.
Not in NN Global.
Not referred to. None of these.
Lord, 62 is the penalty provision.
That's right.
Correct.
Just see what.
Penalty for executing, etc., instrument not duly stamped. Any person, my lord, not duly stamped, voting or attempting, shall be punishable with fine, etc., etc.
Why we ask you to read section 62? It's a conspectus of all these provisions, apart from the explicit language used. The conclusion is inevitable that it is absolutely imperative and mandatory. You
Well,
can have a situation.
I am not disputing
what you're saying
the
is-
mandatory nature of the, my lord, but, my lord, there's this but is there, my
It
lord.
could be directly. If it is directly, you are right.
But, my lord,
We have to first clear the air there. It is mandatory.
it may be mandatory. I am not saying, I am not arguing it is not mandatory. I am saying, my lord, we are at a situation, my lord, prior to curability. We are not at the stage of curability. My lord, it can be cured temporarily affliction. That's a secondary argument. My lord, I am on the first argument. The first argument is that the agreement, and that is why, my lord, I cited all those Calcutta judgments to show that even in unstamped document, my lord, the underlying agreement is valid in law. It is not unenforceable in law within the meaning of 2G.
It is not, it is unenforceable unless and until amends are made
My lord,
known to law.
My lord,
If it remains unstamped,
my lord, it does not
Yeah.
make it void.
no, what you're saying is, we are talking about unenforceable, not don't bring in void now. It will get a little bit more confusing.
My lord, because
We are
please,
just
please-
deal
my
with
lord,
enforceability. We are
please see
just-
the sentence. My lord, let me read the sentence again.
That's right.
We have seen how, my lord, I'm saying this is wrong as a proposition of law. Under the stamp agreement, an agreement does not become a contract.
That's right.
My lord, that's a huge leap. Because if that is the case, my lord, it will impact on all sorts of other, my lord, legislations. For instance, limitation. My lord, there are at least 4 or 5 such procedural laws where, for instance, there is an agreement and there is a bar of limitation. My lord, the examples given in Mullah. So, my lord, if now the court holds that an
What is the
agreement,
example with regard to limitation and
I'll show the Mullah commentary. My lord, limitation. I have got a copy of the Mullah commentary, which I will show, my lord. My lord,
That expression is because, see the corollary of 2H.
sorry, my lord. 2H
Agreement
there.
enforceable by law is a contract.
Right. So, my
So,
lord, either
if it is not enforceable, what it is?
2G.
It is not a contract.
2G, my lord. No. Please see 2G. An
It's
agreement
also you-
not enforceable by law is said to be void.
You see H also.
H, my lord, no difficulty. Your
An
lordship
agreement
hold.
enforceable by a law is a contract.
My lord, your lordship.
Therefore,
Yes.
not enforceable. How it can be a contract?
My lord, it
That
has to
contrary
be.
is, that is the statement therein.
My lord, it has to. The question is this.
Vanity, the real question will be, what is the meaning of the word enforceable?
My lord, the word enforceable with respect, my lord, is not there in either the Contract Act or the Arbitration Act. It is there, my lord, in 45, which is unenforceable, my lord, not to be performed, etc.
That's right.
It is not there in 11.6a. It is not even there in 8.
We are asking you, what is the meaning of the word enforceable?
My lord,
Why we are asking that question? There is a reason. A contract is made by a party.
Correct.
Between two parties.
Correct.
Naturally, it can only be between two parties. It is required to be stamped. To make
Yes,
it to be
it is
stamped.
required to be stamped.
Take that as an example. Now, as you saw, the point of time at which actually it has to be stamped.
It has not been stamped.
17.
Not stamped.
It is not stamped. No, the parties may give and receive benefits, goods, services
Only
without actually complying with the requirement of the second, whatever is the provision under the Stamp Act which mandates it, violating the time also, section 17.
17 is valid.
They don't go to court.
They don't.
Just listen.
Right.
They may actually, under the shadow of secrecy, means that the light of day, it doesn't come down on this transaction at all. They perform this contract. Fine. It is absolutely fine. They're performing it.
There is still a contract.
The question is,
it's still a contract.
No, we are saying the enforceability must be determined with reference to whether if this document is produced in a court of law or a tribunal or a quasi-judicial body or a public office, what is to be done with that document will determine the question as to whether it's enforceable.
Those are questions of enforceability, admissibility, etc.
It cannot be acted upon by a court.
My lord,
Therefore, what you're trying to say is enforceability would be understood as that document cannot be the fountainhead of a claim in a court of law.
very well, my lord.
It cannot therefore be enforced.
Very well, my lord. So far, so good. But, my lord, but this sentence which says that the agreement does not become a contract, my lord, is considerably further than that. It has many implications because, my lord, why is it necessary to say this? Because then the next line is that since an agreement does not become a contract, it does not exist in law. To get over, my lord, 11.6a. So, my lord, if I can convince your lordship that agreement has become a contract, but subsequently may not be enforceable, my lord, it's a different situation. Please keep that distinction in mind. That's the same problem with para 146. Three things have been said in 146. Please see 146.
Yeah,
that is equally confusing. And then I will show your lordship the law commission specific to stamping, specific to the issue raised, and, my lord, the commentary in Mullah, which your lordship has already seen, to see what is the distinction that Mullah draws. And my lord, I will say that Mullah states the law correctly. There is no difficulty in that. Your lordship will see that also. Kindly see 146. I'm sorry, my lord, I'm taking little bit of time on this because this question was squarely raised, my lord.
So this has to be dealt with.
It has to be dealt with.
235.
146, your lordship will
We
see.
got it
Page
35 of the combination.
235 of the page, my lord, 115 of the report, 149. May I read it, my lord? Please note there are any number of different ways this has been put, my lord. Please keep existence in one bucket, validity in one bucket, my lord, enforceability in one bucket. Everything has been elided in this paragraph. I'll show, my lord, three different sentences in three different places. We now proceed to examine the question whether the word existence merely refers to contract formation. And I would say it refers to contract formation as a matter of law. Namely, you must, my lord, fulfill section 7. I'm not arguing that it is a waste paper, my lord. And so it will require contract formation if it is by an alien enemy or it is otherwise void because of a minor. My lord, certainly the court will, you will not appoint an arbitrator. So, my lord, to that extent, no difficulty. And excludes the question of enforcement validity. Now, my lord, how do you equate validity with enforcement? Validity, my lord, is a question of voidness or validity. That's how, my lord, 11 is, 16 is. So, my lord, enforcement is brought into validity, which is not there in 11 in any case. But anyway, on jurisprudence, and then the judge realizes that there's a problem here. On jurisprudentially and textually possible to differentiate between existence of an arbitration agreement and validity, such an interpretation can draw support from the plain meaning of word existence. However, equally possible jurisprudentially to hold agreement has no existence if it is not enforceable and not binding. Well, there's this problem. It can be binding but yet not enforceable. So, my lord, again, two problems here. Existence of an arbitration agreement presupposes a valid agreement, no difficulty, which would be enforced by the court by relegating the parties. Legalistic and plain meaning, your lordship may leave. A reasonable and just interpretation of existence requires understanding context, purpose, relevant legal norms applicable for a binding enforceable arbitration agreement. Agreement, evidence, and writing has no meaning unless parties can be compelled to adhere. A party cannot sue and claim rights based on unenforceable document. Thus, there are good reasons to hold, this sentence I have no problem with. Thus, there are good reasons to hold that an arbitration agreement exists when it is valid and legal. A void and unenforceable understanding, again, my lord, we are on void. Void is equated to unenforceable. Is no agreement. Existence means arbitration, my lord, look at the last sentence, meets and satisfies statutory requirements of both the arbitration agreement. Of course, it has to satisfy, and the Contract Act. And when it is enforceable in law, my lord, enforceable in law goes back to 2G. So, my lord, everything here says 10 different things. So, my lord, I would beseech your lordships to keep enforceable in law separate from enforceable. And, my lord, this is a distinction which flows from a Privy Council judgment, which has been recognized by, my lord, the first Law Commission. 13th.
There are good reasons to hold that an arbitration agreement exists only when it is valid and legal.
Valid means, validity means, my lord, it's not void. Legal means, my lord, it is a concluded agreement. It can't be, my lord, that, but does that include, my lord, everything to the end? That's the question, my lord. We are looking at existence. We've not even got to validity. Whereas, my lord, 45 says void, inoperative, incapable of being performed. So, my lord, we have stretched it right across. Please see, my lord, the Law Commission, because this will answer the question. If it is held that an unstamped document is not an agreement, is not a contract, my lord, I can think of at least, my lord, 10 or 20 very startling results on that. If it's not even a contract, my lord, it will have very interesting implications. That means there is no concluded contract at all. Please see, my lord, the Law Commission's report, copy. And then I will show your lordship the commentary in Mullah, where this distinction is made. Now, this is the 13th report of the first Law Commission, MC Setalwad Law Commission, my lord. And please come, my lord, to para 26 straight away, which is at the bottom of the page. I want to read it a little carefully. The Director of Legal Studies, your lordship got this? Clause G?
We got it.
The Director of Legal Studies, this is the Madras Law College, has also made the suggestion that it should be provided in section 2G that agreements of imperfect obligations are not void but only unenforceable. He has mentioned an unstamped document as an instance of such a case. Such an instrument, which is a record of an agreement, is neither receivable in evidence nor can be acted upon. 35. Since the decision of the Privy Council in Mahant Singh versus U Bayi, which I will show to my lords, the law is well established that the expression unenforceable by law does not mean unenforceable by reason of some procedural regulation, e.g. law of limitation, but unenforceable by reasons of substantive law. In view of this, it is unnecessary to introduce the change. So, my lord, what the Law Commission was put to was the Madras gentleman said, please clarify the law that an unstamped is not void.
What if an arbitration agreement is made compulsorily registrable? Is registration a matter of procedure, like stamp? What would happen then if
my lord,
it's not registered?
If my lord, if it was compulsorily registrable, my lord, and the consequence of, my lord, there are two stages in any situation. No? One is what is the law, and two is what is the consequence. So, my lord, one, what is the law, mandatory, directly, nobody is running away from that. what is the consequence? If the implication of the law was that if you did not register, agreement would be void, my lord, it would stand on a completely different footing. And my lord, your lordship will just see that one passage in that Calcutta judgment only on this and on our stamp act. I'd shown this, my lord. Please see page 39 once more. All those cases, my lord, go the same way, but please see 39, compilation 3. My lord, because this is an academic discussion. We need to, my lord, either way, your lordships need to decide on. Let's get a Mullah. My lord, just see page 39. Your lordship's got this ILR judgment. There are 4 or 5 judgments which say this. I am only showing one page.
Yeah.
39. Mr. Basu's first contention. Lordships have it. 39.
Yeah.
And so the document is not valid because it is not properly stamped. Then, my lord, 35 is set out. The effect of the section is to make such an unstamped document inadmissible in evidence and unable to be acted upon by persons having authority to receive evidence or by any public officer. It does not affect the validity of the document. There is a clear distinction to be drawn between invalidity and inadmissibility. Certain statutes and sections render documents invalid if they are not stamped. No section of the Indian Stamp Act has this effect, but an instance of a document being rendered invalid by omission is contained in the English Stamp Act. So, my lord, if the consequence which was provided in our Stamp Act was not 62, but a clause which said that if you have not stamped it, it is invalid, then, my lord, it would be void and then the consequences would follow. My lord, and that is the reasoning also in the other judgment, my lord, which I had shown your lordship, which is the PLD judgment. That's the entirety of the reasoning is only on this. My lord, your lordship will just note page 108 to 110 of that paperwork. So, my lord, this is so far as these 2 paragraphs are concerned. Your lordships have seen the suggestion made and the understanding of the law commission. My lord, and that is also the understanding in Mullah. Please see Mullah now. 2 pages of Mullah. My lords may just see Mullah page 111 at the bottom. The lordship has already seen this.
Yeah.
I could make out. But I had also photocopied it for the same reason, my lord. Please, it is actually consistent with what I'm saying.
Yeah.
The words not enforceable by law in this section do not refer to a disability to sue arising under any procedural laws like the law of limitation or civil procedure. The unenforceability contemplated in this clause is one arising under the provisions of substantive law, and my lord, the Privy Council judgment is quoted. Then please see the next sentence. It may be declared void by this act or by any other law. So, my lord, if the Stamp Act had said unstamped agreement is void, then certainly, my lord, it would not exist in law. There is no problem. But our Stamp Act, for whatever reason, does not go that far. Then, my lord, a contract void since is no contract at all. Then, my lord, what your lordship would have said, there is no existence of any agreement. We would go back from validity to existence and say, maybe it exists. In fact, it does not exist in law. For instance, my lord, a contract to resolve family dispute or divorce, that would be void. ab initio.
You have not completed reading that page.
Yes, I'll complete.
Important heading.
Sorry, my lord.
Unenforceability.
Sorry, my lord.
Unenforceability.
I'm reading unenforceability. I'm reading
That's
that. my lord.
important.
Of course, I've seen that. my lord.
That is important.
Unenforceable contracts are valid in all respects. So, my
That's
lord, that
exactly
is
what we were saying.
that's what. But may not be sued upon by the parties. Such a disability may arise for want of registration because the time prescribing the suit has expired. Firm has not been registered, or document does not bear the requisite stamp duty, or because lender of money does not put. So, my lord, this is the distinction.
Therefore, the distinction, if you were to go to a court of law or a tribunal or whatever, under the aegis of the state,
In general, my lord, there is no
you cannot
dispute.
enforce it unless that, the
No difficulty.
The shadow is, removed.
My lord, that's the second point. Whether 33 and 35 problem comes or not.
That's right. No,
Right.
we are on the general
My
principle.
lord, the general principle is
Forget about arbitration. Suppose
it is valid.
It
It is valid.
is enforced unless and until you go 33.
My lord, it is. Let me put it.
Stamp duty
My lord,
paid
it
law.
exists in law. It exists in law. It is valid.
In a manner of speaking.
My lord, that's
When
what.
you say exists in law,
My lord, existence.
it's a
It is. My
a
lord,
very unique kind of a thing.
My lord, it is valid. It's valid, my lord. That's what it says. My lord, I am reading this. It is not unenforceable law. It is valid. It exists. It is valid. But as your lordship puts it to me, in the normal case, it cannot be enforced because there is a bar under 35.
33 also.
33.
You have-
33.
when you reformulated the question,
33.
you have not referred to 33.
33. I agree.
33 is important because 33, the moment this document is produced before,
No, that's where I have a different submission. my lord.
it is obliged. Justice Ravindran says.
My lord, that is where I would beg
It
to
is bound to impound it.
slightly differ on.
What happens to the
My
transaction?
lord, just there is exactly what, my lord, I would like to differ on two counts. My lord, my lord, therefore, this sentence with respect in paragraph 22 and 29 may not be strictly correct because it is enforceable in law. It exists in law. The two, my lord, 22 and 29, this is not the effect of the Stamp Act. The formulation.
May not be enforceable. We are trying to elicit a reply from you.
My
May
lord-
not be enforceable in the sense that as an unstamped document cannot.
No,
be-
that's the second part. I am only on, my lord, I have to first get
The
over.
parties, we told you, the parties may actually.
So, my lord,
stop
to-
there. If you
to
read
that,
section-
all I'm saying is, to
I'll
that
give you an
extent-
example. Please read section 8 to the contract act.
Section 8.
8 to the contract act.
Acceptance by performing conditions or receiving consideration. Performance of conditions or acceptance of any consideration for a reciprocal promise which may offer proposal as an acceptance of the proposal. So, my lord, there is.
Why we asked you to read this is, see, the parties performing the contract may begin even at the stage after the proposal is. How do you begin a contract? How does it lead to formation of a contract? Somebody makes a proposal, person called proposer, promise, accepts, consideration, agreement. These are the, how an agreement.
Lord,
formed.
I'll put it
What
with.
you're saying is, persons may perform. And we have no difficulty
My
about
lord,
that.
may see 10.
But then,
Please
if
see
you
10.
enforce it,
My lord, please see
it
10.
remains unenforceable.
Please see 10. Please see 10 and read para 22 and keep them together.
That's,
It will not work, my lord. That sentence will not work with para 10, with section 10.
That's right.
My lord, it may be your lordships may arrive at the conclusion which the other side wants, or Justice Ravindran's conclusion, without incorporating this reasoning. I am first demonstrating, my lord, this reasoning is wrong. Then, my lord, the second question, whether you are the court can go ahead violating law. That's the second question.
even there we are saying it is not enforceable what Justice Nariman says.
My lord, please see the sentence again and please keep.
It's not enforceable.
That's not what he says, my
He
lord.
said you can't unless you remove the shadow
My lord may just
of
see.
it being unstamped or insufficiently.
That is what he could have said. But that's not what he said, my lord.
Huh?
That's not what he said. That is what your lordships are saying. That may be a
Okay,
reason.
let us put it that what I am saying,
My
or
lord,
what we are saying.
can I read that
What's your
sentence?
answer to that? Because
That's the second question, my lord. I'm coming to that. Let me just, my lord, just see the sentence. I'll show the sentence again. My lord. 22.
Right.
My lord, agreement does not become a contract.
Sorry.
unless the document is stamped, agreement does not become a contract, namely that it is not enforceable in law.
That's right.
Now, my lord, namely that is not enforceable in law,
Right.
please cut out. And instead of enforceable in law, my lord, put the word void.
We understand where you're going.
So, my lord, that is not consistent with 10. So far, so good, my lord. So, your lordship, my lord, this reasoning may not justify the conclusion. That's all I'm saying. My lord, I still have to deal with SMS. Now, my lord, the short question
Does
is,
the word void always carry the same meaning in law?
my lord, 2G, my lord, void has a particular meaning in the Contract Act. Void has that meaning, my lord, right through. Validity is also an expression used in the Arbitration Act. My lord, it can't be semi-void, my lord. It can't. It's either, my lord, it's void or it's, my lord, not void. If it is not void, it may be unenforceable. That is what your lordships are putting to me. But certainly it is not void. It may be unenforceable. That's a separate, my lord, limb.
Can an unenforceable agreement be said to be existing?
Yes, my lord. It is existing in law. It is a contract. It exists. The moment I signed it, my lord, and I give, unless the statute, my lord, prohibits it. It exists. Between me and him, it exists. In law, there are obligations which I am in law required to perform, my lord. Even if it is unstamped, that obligation is still there on me, my lord, which I am required to perform. It's
So
a
you
non.
don't perform your obligation. You don't perform your obligation. You said you have obligations.
Well, no, then you get to the next stage of unenforceability, but it's a contract.
So when it
It's a
goes
valid
to court,
contract, my lord.
Therefore, it is unenforceable.
Well, Lord, I am not saying that it's not unenforceable. I am only saying that, well, Lord, I have to get to first, well, Lord, I have to get over paragraphs 22 and 29, where the learned judge realizes the problem, my lord,
Yes.
because the word is existence. The word is not enforceability. So he has to get to existence. To get to existence, you have to say it is
Void.
It's void. But that's too much of a leap.
Mr. Banerjee, perhaps what you have said so far, Stamp Act does not say that it becomes invalid.
Correct.
The document exists.
Correct.
Now, certain obligations are to be done, like stamping.
Right.
Now, if it is not stamped, then maybe consequences of not being enforceable may come in.
Including, my lord, punishment also. Supposing.
Penalty, of course. But then does not mean that it is a void document.
That's right. This is my assumption.
Or it does not exist.
That's right. That's the assumption. Now, my lord, I go to the second question. The second question, which is bothering my lords, is that how can we be a gun to our head be put and said that no, just ignore the Stamp Act. Just simply ignore the Stamp Act in the interest of arbitration. My lord, that's the question. Why should we as a court condone a breach of law? This is the question, my lord, which is put, squarely put, my lord. To which my answer is, my lord, it's a circular question because everybody assumes, my lord. I will show, my lord, I will answer this in two ways. My lord, one is that there is just, my lord, should I just tender that Privy Council judgment?
Certainly.
That
1939.
Yes, just a minute, page 113, just to complete the, which is the judgment required. My lord, the question presumes that by the judge referring the matter to arbitration, he violates 33. It has to be done, my lord, instantaneously. Correct? This is what has been put against me. My lord, there is an assumption that I am violating the law. My submission is that, and I made this before, my lord, and I'll give now two reasons why I say this, my lord. We are still.
Bear in mind section 8 also.
Section 8 also. Section.
Rhodia says 8 and 11 are
Right.
alike and similar.
Both, my lord, the logic will be similar, my lord. My lord, one is that there is my lord, two submissions, my lord.
Yes.
Two submissions, my lord. One is that there is an inconsistency between 11.6a and 33(2), both cannot operate. 11(6)(a) and 33(2), both cannot operate. 11(6)(a), and this is a point, my lord, which has been pointed out, my lord. I had pointed this out earlier. It is there in intercontinental waterline in paragraph 29, one of the subsequent judgments, my lord, that if the 11 judge has to do the exercise under 33, he necessarily has to go and look at the substantive agreement. My learned friend gave the example, the guidelines, etc. So the necessity of looking at the substantive agreement comes from 33(2). That's his job. But my lord, that job is beyond the job in 11(6)(a), which is restricted to examination of the arbitration agreement alone. So, my lord, one, I've already argued that. My lord, but there is a much more fundamental point which only came to me when your lordship raised this issue about the scheme. If your lordship sees the scheme, and
You have not done this, you have not, which portion you wanted?
my lord, page 113, it is there in the, it's there in
That's
the,
the case where the question was, I think the failure to sue within a time,
right, my lord.
that would not make it the contract unenforceable.
Correct.
That's
So, my lord,
absolutely right.
my lord,
That is a different issue altogether.
my lord, the parallel is very similar, my lord. It doesn't make the, my lord, it's not a question of making the contract.
It will not make the contract unenforceable.
My lord, the contract, again, my lord, your lordships are depriving the party of a remedy.
That's right.
Here also, the same thing. Your lordships are depriving the party of a remedy. So, my lord, it is in that sense.
Are you visited with any penalty for doing that?
Yes, my lord.
Like in the stamp act?
Yes, 61, 62 penalty.
No, we're talking about in respect of somebody who's failing to sue for.
Your substantive rights go, my lord. I'm not sure that, my lord, any penalty is.
It's not a case of an unstamped document.
No, it's not a case of an unstamped.
It's a question.
It's a limitation, my lord. The parallel, the law commission.
Say, by analogy.
Yes, that's what my lord Mullah says. That's what the law commission on that basis, my lord, did not clarify 2G. It does not cover void. Even the law college lecturer said, professor said that it is an imperfect obligation, doesn't make it void. Even he was saying the same thing, my lord. So, my lord, whichever way this was the judgment referred to in the commentary and the, my lord, explanation I am mentioning.
Good.
My lord, the parallel is right exists, remedy goes.
Remedy goes.
Remedy goes.
Exactly.
Remedy goes.
That's it.
So, my lord, this is the limitation, right exists, remedy goes. Here also, Stamp Act, right exists, remedy goes. My lord, here, of course, remedy goes temporarily. There, remedy goes permanently.
Permanently.
Right. So, my lord, that may be a slightly different case, but it doesn't make it void. That's all I'm saying. Now, my lord,
here there's a difference. Here, the course to be followed before your right is being extinguished, that is also mandated by statute.
what your lordship is saying is that I'm answering the second question. What is mandated by statute?
Mandated by statute is your
33, my lord.
moment of time you cannot enforce it, but court will take it,
My lord,
send it somewhere.
I'm obliged. My lord, that is what is that point in time? Is that point in time when the matter comes before the 11th judge, or is that point in time when the matter comes before the arbitrator? That's the question, my lord.
Ultimately, that's
Right. Now, my lord, when the matter comes before the learned judge in 11, he deals with it as per the 11 scheme. Please now see the scheme.
Mr. Banerjee, why is it in section 8 and section 11 brought in by the same amendment we're taking?
Correct, my lord.
Slightly different wording.
I'll explain, my lord. I'll explain, my lord. Lord, I have some internal knowledge of this. 8 and 11, the Law Commission wanted to use the word null and void, inoperative and incapable of being performed, which was, my lord, the legislature had a rethink and curtailed 8 to some extent and curtailed 11 even to a greater extent. Well, there are some file notings as to why it was done, but nothing of it is on record. But the fact is that the legislature went one step beyond the Law Commission's recommendation by narrowing the field. So, my lord, today the question is how wide will your lordships open the door? That's the expression Justice Nariman used. The door was wide open in 11.
In Drodia, the three judges bench has equated section 8 with 11.
Right.
Virtually.
My
The
lord,
distinction in phraseology, what you're trying to tell is
my lord, there are 2 points to
validity, prima facie validity under the valid does not exist is what section 8 says. Now, section 11 doesn't refer to validity at all. It just says
existence.
So, Drodia actually has
Expands existence to include validity.
validity.
Right. My lord, it
So
does. There's an issue there. There's an issue there. But, my lord, the reason it equates it, again, we go back to para 29 of the Law Commission report. There are two issues. One is, what is the scope of inquiry? What are the arguments you will permit? That may be narrower in 11 and wider in 8. But the standard of prima facie may be the same in 8 and 11. So, my lord, that there is no problem. Prima facie standard of 11 has been read, 8 has been read into 11.
We not really understand section 6A as being incorporated for dealing with a particular evil. As
My lord,
or
right. What was that evil?
That evil was the view being taken by
My
the
lord,
court, including in SPP.
The view, my lord, what the evil was a simple evil. The evil was that the door was open. That door has now been possibly, my lord, narrowed.
And the specifics of those, the way the door was.
My lord, I have some. The Law Commission has mentioned two. My lord,
it is referred to in the Law Commission.
My lord, the Law Commission has mentioned two judgments.
That's right.
But the section says, notwithstanding any judgment, my lord, there has been discussion post the Law Commission and before the section has been introduced, which is not there before, my lord. So, my lord, the section says, notwithstanding any judgment, it is this concept, my lord, that somehow it is restricted. The amendment is, my lord, why was the amendment made? Let us, my lord, be blunt about it. The legislature did not want the courts to look at too many issues. That's why they did it. They've gone one step further in 2019 and said, now thank you very much. Let's get institutions to a point, which is the case in, my lord, Singapore and my learned friend was citing those Stamp Act. They are not relevant because there the institution appoints. So, my lord, the mischief rule, if your lordship wants, is that the entire purpose of 11.6a was to narrow the field. SBP was the 7 judges. So, my lord, that was the elephant in the room. My lord, one has to get beyond the SBP mindset. It was to narrow the field.
Exactly.
Now, my lord, when you narrow the field and bring it down to existence, the question your lordships are putting to me is, in the process of deciding existence, should we not also decide stamp? This is the question. This is the question.
Are we not bound?
Are we not bound? If your lordships are not bound, then your lordships may not do it. Correct. Now, my lord, how I'm answering that question, my lord, in 5 minutes. My lord, please see the appointment of arbitrators by the Chief Justice of India scheme. Please.
We got it.
Just my lord, what is to be submitted under the scheme? And I'll give your lordship a practical example of NN Global. Please see the scheme. And this is something your lordship pointed out to me yesterday.
That's right.
This is a statutory scheme. And I believe, my lord, this is in our enthusiasm and my enthusiasm, my lord, to argue large points. And one misses, my lord, a more simple, straightforward answer. Now, my lord, the purpose of 11, my lord, it's a summary proceeding, whether before or after SBP, whether judicial or not, my lord. My lord, it is at page 65.
Yeah, we got it.
Scheme may be called so and so, and there is similar schemes, my lord, in the High Courts also. The request, it's a request to the Chief Justice
Or certified copy.
or a certified. Now, my lord, right. So, my lord, before you come to this court, in 99.999% of cases, and my lord, the reason is also there. If your lordship sees Order 8 of the Supreme Court Rules 2013, the copy has to be certified by the AOR. So, my lord, nobody files any original. It is sufficient for exercise of 11 jurisdiction to file a copy.
Absolutely.
Now, my lord, what is the consequence of that?
Yeah.
My lord, the consequence of that in very simple terms, there's a constitution bench in Karamchand Thapar, which your lordships may be familiar with, which has been consistently followed, my lord, by 5 judge, 3 judge, 2 judge.
That
Is
will not apply in a copy, in the case of a copy.
that, my lord, a copy is not an instrument. If a copy is not an instrument, my lord, 33 will not apply. Neither will 35. That's the short answer. What the consequence of that, I'll come to. So, my lord, if I, in every case before my lords, there is a typed copy with a signature by the AOR.
We come to paragraph 20 of SMS.
SMS.
SMST.
SMS. In fact, my lord, I'll go one step further. My lord. The court, even a fully constituted court, cannot compel a party to produce the original unless he does it voluntarily, my lord. In fact, in NN Global, what happened was, I don't know, the direction may be 142 or whatever, my lord, the party was directed to produce the original and have it impounded and stamped. Today, my lord, in an 11 before my lords, there is no document which is required, no instrument which is required to be impounded. And my lord, this makes perfect sense. When there is a trial, when there is a document, when there is an exhibit.
Paragraph 20, please.
20.
Paragraph 20 at...
The scheme requires an application, so and so by. In fact, such a requirement is found in the schemes of, if what is produced is a...
Just a moment. Please. Paragraph 20.
Right, my lord. May I read? It's very important. It's very important.
Because it's been interpreted by this court, that's
Right.
why we are telling you.
The scheme for appointment requires an application under Section 11 of the Act to be accompanied by the original arbitration agreement or a duly satisfied copy thereof. In fact, such a requirement is found in the scheme rule of almost all high courts. What is produced is a certified copy containing the arbitration clause. It should disclose the stamp duty that has been paid on the original. Well, this is an addition by the court. My lord, it is not there in the scheme. Section 33. My lord,
This is what we are trying to point out to you. Even if it is a certified copy, the requirement of law has been
My lord,
declared by this court.
in a
That is how
certified...
it was being done.
Maybe, my lord. But your lordship is laying down the law on this, my lord. And if a certified copy is filed before my lords, my lord, the question I ask myself is this: is it an instrument? No, it's not an instrument. It is not the stage at which impounding will normally take place. Ex facie, there is no violation of 33 and 35. This concept that you must, my lord, the document comes and like tigers, my lord, we must impound, may not be, my lord, stricto sensu, my lord, what is there. That stage will come. Nobody is going away from that stage. That stage will come when substantive rights are thrashed out and the document is exhibited.
What will happen to a Section 8 application? So there you have to produce original.
Or certified copy. Or certified copy.
No, Section 8.
8 also certified copy. Same problem.
Certified copy is permitted.
Yes.
Is it permitted?
Yes, my lord, it is permitted. My lord, in every high court, my lord.
How, Section 8, we are talking about 8. Where is it permitted?
Let's,
How do you say it is?
why did that? Where the original arbitration agreement or the certified copy thereof is not available with the party. In fact, Section 2, the application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. Then the proviso comes in.
So, my lord, we cannot be certified.
Not be because under Section 90 of the Evidence Act. 91 of the Evidence Act. Sorry, 60.
My lord, your lordship is right. 91 read with 60. That the
Original document must be produced.
That's not document.
Secondary evidence is produced.
yes, secondary evidence, my lord, normally is not permissible.
Not permissible.
But my lord, secondary evidence is permissible in a section 11 situation.
You're right.
So my lord, so this problem that we are, my lord, building up to such a level, my lord, frankly will come when the court is confronted with the document. And the document...
Mr. Banerjee, just to take it forward, you said that I had a simple answer. I was looking at the
Scheme.
wood and I was missing the trees.
Right, my lord.
You see, the scheme, it talks about an original arbitration agreement or a duly certified copy thereof.
Correct.
Now, that is not something which is impoundable.
That's not impound.
And what is also provided in this SMST state in paragraph 20, as just Joseph has pointed out,
Right.
it should disclose the stamp duty that has been paid on the original. So it has to disclose the stamp duty. The court in section 11 is not something which is impoundable.
I am obliged. And therefore, my lord, 33 will not kick in at that stage. 33 will kick in at when, my lord, when actually you are, my lord, going, my lord, proceed on. And that is why, my lord, that GT said judgment I showed, my lords. I'll show that again, which is section 9, where the court, my lord, finds that I have to look at this agreement. I can't impound it. Therefore, please pay security. In an interim relief, my lord, how does the court, and the section 8, somehow the court will protect, my lord, but that will come as a condition of the, my lord, interim relief. So, my lord, where is the bar in 33? I submit, my lord, that bar can legitimately be postponed to the arbitrator, because he will have to, my lord, look at the substance. Let us take this example forward, my lord. This is an unstamped document. I am the arbitrator. I will simply say that this is an unstamped document. It can't be stamped. I will not take it into account at all. If you voluntarily produce it, have it stamped, we go ahead. But that is a decision, my lord, to be taken by the arbitrator and the voluntary nature. Please see what happens in NN Global. You are forced to produce the document. You are forced to pay 8 lakhs, which you say you shouldn't pay, and your bank, and it is impounded by the registrar, and your bank guarantee goes. My lord, this is the implication. If today in 11, your lordships are to decide all the issues which my learned friend said, how much is the stamp duty, who is the right party, who is to bear the amount, etc., even albeit on a prima facie basis, my lord, I would respectfully submit that the door would be a little wide open, which perhaps, my lord, was not really the intention. My lord, I'll just show, my lord, I would put it in a different way. Your lordship says, is it a court to receive evidence? My lord, I would say that it is not a court to receive evidence in that sense. It's a summary court which can take within its fold even a photocopy. Of course, certified. So, my lord, whichever way your lordship looks at 33, and it's a fiscal statute, it has to be read strictly. If I can get out of it, then it's between me and the government. Then it is, the court will not go overboard to protect the government. It's a fiscal statute; it has to be read strictly. If there is
a tax collector.
Sorry, my lord, court is
not become a tax collector.
So, my lord, before the arbitrator, the original will be called for. It has to be called for if you want some substantive relief. And if it is not, the arbitration will end.
That constitution bench
Right.
about
what I have done is, there are Karamchand. What I have done is, there is one judgment of Justice Sanjeev Khanna in the Delhi High Court where he chases the full history. Constitution bench, 3 judges, 2 judges, etc. That one judgment. I am taking. There's also a Bombay High Court judgment, but I will show that separately if required. What happened in this case was that there was a development agreement between 2 parties. The photocopy of that was shown to the collector. The collector said, produce the original, show cause to produce the original, and impound and pay penalty. So, my lord, collector caught hold of the document and said, now you must pay. In that context, my lord, what the High Court does is, the lordship first sees paragraph 15. Section 14, my lord, starts with 33.
Yeah, 62 Supreme Court.
Yeah, 60. My lord, it is 19. We've given the list. 1962, 1 SCR.
It's available in 62 Supreme Court,
Yeah.
110.
Yes,
Yeah.
my lord. It is quoted, my lord. Paragraph 6 is quoted.
That we just want to see that.
It's-
Yeah, 62 Supreme Court.
My lord, it is 1962, is the same judgment. 62, 1 SCR.
Yeah. 110. Yeah.
62, 1 SCR. No, whichever one your lordship wants to see. 827. It's the same, Karamchand Thapar. There, my lord.
This argument would apply only if a certified copy is produced, of course. This argument that you are building up on the basis of the scheme, if the original document is produced.
My lord, if the original document is produced, my lord, in the extremely unlikely event, that's not
What
even...
will happen in the arbitration if also he produces only the certified copy?
Finished, my lord. The arbitrator will say, I will not go into this at all.
Produce the original.
He will have to produce the original. So, my lord,
How do you admit the document?
my lord, that will be at that. There's no difficulty, my lord. I am not saying Stamp Act will not apply, my lord. I am only postponing, my lord, the event.
Yeah.
One of the last portion. So this judgment actually quotes all the 3-4 judgments in one. So that's why I had given it.
Yeah.
This is, your lordships have the AIR or the SCR?
SCR.
SCR. Right at the end, page 834. It starts at 834. It is next contended. That's the passage which has been set out by Justice Khanna and the judge.
Yeah.
You may read, we can follow from the quoted part that is already there in.
It's already there. It's the same quoted portion. And all the other judgments, my lord, if it is an original agreement, my lord, I would then fall back on my argument on 33(2) versus.
Examine.
Now, my lord, if it is an original agreement, which is only the arbitration agreement, my lord, I may concede that arbitration agreement, but that is, my lord, 5,500 rupees. It's
Nobody is going to.
So, my lord, the practicality is, my lord, threefold. Original arbitration agreement produced only standalone, perhaps, my lord, there may be an issue. Anything else, my lord, it has to go to the arbitrator. My lord, also what fell from my lord Justice Rastogi, if there is a doubt as to the extent of the stamping, that, my lord, also is, once prima facie case is seen, that also should go to the arbitrator. That is, my lord, Weatherford? No, Interline. That was the view taken in that 3 judgments, that, if there's some dispute regarding stamping, then also, my lord, in Vidya Jolia, it should go.
What the court really held was the copy could not be validated.
Correct. Copy cannot be, my lord, validated. Validated.
Copy, because the facts, you have, that's why we wanted to see this judgment.
My lord,
There's a decree, because that was, I think, an award.
My lord, a copy, in fact, my lord, the law is that a copy is not an instrument.
It was found to be the original.
Yes, it was, they got around it, my lord, they said, yes. But, my lord, there are a number of judgments after that. An instrument under 214 has to be the original instrument. That is the understanding of 214 of this court. My lord, it cannot be, because even, my lord, even if you purport to impound a photocopy, you cannot, by paying stamp duty, cure what is incurable. So, my lord, that's a different scenario. That's a separate situation. In a photocopy, there are extreme cases where you lost the original. and you say you've lost the original and photocopy is there and you are willing to pay. And even then, my lord, some courts have taken the view that that is barred under the laws of evidence. So there are extreme views like that.
Good to hear that you're using the word incurable.
That is, my lord, incurable where it is a photocopy.
That's right. We thought
If it's a photocopy.
that's right.
But, my lord, I am simply saying that 33 and 35 will not engage at this stage because you don't even have the instrument before you. So, my lord, that's the problem. In the virtually all cases, because of the Supreme Court rules, my lord, a certified copy is put up and that is sufficient. Nobody, my lord, wants to put in a doc. So even
Supreme Court rule is original or certified copy.
no, my lord. Please
is
see
so.
the rule. Rule is certified copy.
Original or.
Please see the Supreme Court rules 2013, 8.
Okay.
Rule 8.
Rule.
Rule.
Not the scheme.
Not the scheme is original certified, but the rule is in the normal case, my lord, and that is common sense, my lord, that this court does not want to be burdened with original documents at the stage, except when there's a full-fledged trial or there's a 131 suit, when you then, my lord, proceed and summon exhibits, mark. Similarly, my lord, in a suit, when it comes, order, my lord, when the question of impounding comes, is when the documents, my lord, are filed, the original is placed before the judge, then he takes a call then. Nobody takes a call, my lord, on day one. There's a judgment of Justice Balakrishnan saying that merely when you file, that's not good enough. It has to be, my lord, something which it has to be exhibited, acted upon, etc. So, my lord, my simple point is, let them go past 11. Please leave it to the arbitrator. Please trust the arbitrators. They are, my lord, after all, the alternative dispute resolution, unless your lordships find that there is an insuperable mandatory bar, which then, my lord, of course, substantive law of India, mandatory bar, don't look further, impound. If that is the law, my lord, then of course, my lord, then existence will mean something, my lord, much more than the narrow meaning of Justice Korean Joseph, which says narrow meaning, no more, no less, my lord. Then it will be more rather than less. Then your lordships will have to decide what is the stamp duty. Those are my subjects.
What do you say about this last argument of that? Or based on the scheme, certified copy?
Yes, well, certified, I will take it, that the certified copy is a photocopy, the original agreement. The photocopy, the certified copy means what? It's a photocopy of an original with
And one more thing, you wanted to say something about SMC.
SMS.
My lord, SMS, the problem is that this aspect, my lord, according to me, my lord, it may not be necessary to decide the rightness or wrongness of SMS.
The prior to.
Yes. But in any event, my lord, there also this argument of 33 and 35 that impounding will require the original may not have been.
What do you say about his argument about, that fiction not being carried further than it's required?
My lord, fiction.
About the divisible.
My lord, I am not argued divisible, my lord. Fiction is, my lord, only relevant only so far as 11.6a limits it to arbitration agreement. So it's consistent with that. That's all. I am not saying that fiction overrides the Stamp Act. We are not arguing that the fiction, my lord, overrides some third law. Those 10 judgments, my lord, whatever they say, they say. My lord, I would again, my lord, at the end, request your lordships, my lord, just to see the last 2 pages of my written submissions, because I believe that there is a balance, and also that your lordships may consider, since it is a constitution bench, and whatever your lordships say will be seriously taken by the legislature to introduce this, my lord, control in 16. My lord, it's like a water bottle. If you don't give control in 16, you press hard and everything flows to 11. So we have this 11 jurisprudence going on from time immemorial. Somewhere people want justice, my lord. Whether it is unstamped, whether it is whatever it is, my lord. And that justice is now being postponed till the end. After 1.5, 2 years with 34. So, my lord, if there was a 16, I am confident, my lord, none of these matters would have come. Or maybe, my lord, we are so litigious, still it would have come up, but then your lordship would have given a simple answer, go to 16, sort it out, we'll come back in a.
Yes. Thank you.
Thank you.
You have spent so much of time and energy. We should be thankful.
Not at all, Manoj, it's my privilege.
The expression used is original arbitration of a duly certified copy. I would take it to be a photocopy of the original arbitration agreement, which is either on the stamp, e-stamping as we call it, or wherever separate stamp papers are used, the stamp papers also are included. So entire thing duly certified, which will show what stamp duty has been paid, if any. That is in the sense, it is used in SMS. If what is produced is a certified copy of the agreement, contract, instrument containing the arbitration clause, it should disclose the stamp duty that has been paid on the original.
But can you invoke 35?
Because in my
question, whether you can the whole idea of
in my experience, when you read 33
and 35.
33, 35, and
if a certified copy you don't produce, how can the court impound? How can the court, there is a question of evidence act upon it. The scheme itself and the rules permit a certified copy.
Let us go to clause 33. 33, it says instrument.
What's your answer?
Clause 33 and 35 both talk of instruments which are the original instruments produced. 33 and 35 clause is followed by 38 where it is impounding how to be done. Now let's assuming that the certified copy has been filed and this A discloses that no stamp duty has been paid.
Correct.
Well, certainly not the court can call upon because this was done in SMS.
To match it with this Karamchand Thapar judgment.
Yes.
If that original instrument is not here,
Yes.
we cannot
Let's
impound the certified copy.
please bear in mind that in NN Global, the operative order Roman 2, the Secretary General was directed call upon us to get the document, the original document before the court, and then get it impounded.
No.
And then it was
Whether the legislature has vested us with that power means
if we see
in a global that course has been taken.
Whether it's contemplated under law, that's only question. Whether this is contemplated, if certified copy is permitted. Ordinarily, the original document alone is permissible under the Evidence Act.
61, 62, 64.
Correct. But here the law itself says you can do this, like you read out section 8.
63 and the scheme also.
That's right. Therefore, when the original is not produced, certified copy is produced, you agree it is not an instrument falling within the meaning of the word section 34, 33 and 35.
250.
No,
And the judgments of
35.
there are two judgments which says photocopy. Because I
That's
will
right. Whether there is then this ancillary or supplementary or additional power to when you find stamp duty is not paid or not adequately paid to call for the document and then impound it and then send it. Is it contemplated in law?
was
My lord, if I may just add one line, my lord, the word is examination in section 33. I just also.
Examination of the instrument.
Absolutely, my lord.
Examination of the instrument is the instrument in original.
So, my lord, my only point is that it can be after the certified copy if it is seen that it is insufficiently stamped or not stamped. The instrument can be called for. And then, my lord, thereafter the rest of the proceedings would follow.
It can be called for or has to be called for.
My lord, it should be called for if it has to be proceeded.
Now, where do you get that should be?
My lord, I am only reading the section 33, my lord, and I'm also reading para 20 as my lord pointed out from SMS to say this.
My lord, the High Court judgment which I've shown says, my lord, you cannot call for it. 48, my lord, there are sections in various Maharashtra acts where the collector could perhaps call for it, but that has been interpreted by this court. The court suo motu cannot call for it. My lord, the court cannot call for it in a normal circumstance. My lord, the very same judgment deals with provisions, my lord.
The Delhi High Court.
The Delhi High Court judgment, which follows the Supreme Court. My lord, you cannot, it is to be a voluntary act. You cannot force some.
What we had built up on a huge mountainous scale. If this had been the premise,
My lord,
started from section 8. Section 8 photocopy was filed. And here type
Section
copy
8
was.
also permits certificate copy.
Yes, Section 8 also permits certified.
Ordinarily, in a proceeding,
Because if
only
we-
the original can be produced.
Because
And
if
the
we,
stamp act, etc., comes in when the original is produced.
Yes.
because instrument, if you see
Here
the
we have a
definition.
different kind of regime.
This
Well,
way.
I had not seen this until yesterday when your lordship had pointed to the scheme. Then my lord, this point came in.
Just see the definition of instrument, 214 in the stamp act. Instrument includes every document by which any right or liability is done. So it is an inclusive definition, document. Original does not say, but there is a judgment of this court.
It's a very strange way of, how things happen because this principle is supposed to get at somebody who's producing a certified copy and trying to validate the original document.
Right.
It is that which is not permissible.
Right.
But, in twist of fact, here it works against you because you cannot come in
You can
take
produce it.
stamp duty.
The document was called from me.
You follow what you're saying. Or supposing somebody were to produce the original and seek to validate it. Under section 35, by paying the duty, you can't do it with a copy. You have to it's possible only if you have the original. This is what has been laid down there. But here it's a sort of double-edged sword as it were, and it's working against.
Yes, I will only point out one thing.
Yes, we have to write. So we have heard sufficiently, and I think
Only just one thing, timeline is section 20.
Only one thing, ultimately the argument is that you are trying to defeat the Indian law on recovery of stamp duty. But the argument, if we accept the argument that is put forth, we are not defeating that. Eventually that is being collected. I mean, there is no question of stamp duty not being covered.
Very deeply obliged for this patient hearing.
My lord, there's one judgment.
That's in
Just need
yes.
This
this one.
This is the matter will come on Tuesday.
Deeply obliged.
very
Yes, yes.
This
This is the matter will come on Tuesday.
Deeply obliged.
one.